Yes, the matter of the scientific background and basic on. I am on the only petitioner. I want to submit to reason. Okay. It is already an order was passed. I was rejoin the contempt case. Contempt case. No, reason what honorable court has. They have filed referendum. One referendum has filed an affidavit and certain new documents. In compliance with the order, I have already furnished regarding pensionary payments. And that's why. Okay, right. Mr. S. Sharma, learned counsel for the petition is granted. How much time? On 11 of it. Granted 2 weeks time to file rejoinder. 2 weeks to file reply affidavit. List the matter after 2. That is the matter on 11/10. 11/10. Last for that. Maybe. I get to mention item number 23 meter. Yes. This matter has become in process. Okay. Mr. D.A. Kayum. D.A. Kayum, learned counsel for the petitioner, submits that the matter has become instructed. Who appears for the other side? Like PNRD Malot and the APSC. I have known that. What is the name? Mr. A. On behalf of Mr. B. Sharma, learned counsel for the APSC and Mr. U. Sharma on behalf of Mr. K. Kaur, learned counsel for PNRD department. Also submit that the matter has become instructed. In view of the submission made by the counsel for the party, the writ petition is dismissed as instructed. Okay. Later, I like to listing of petition matter. After notice of it was not expected. Huh? After notice was introduced, thereafter it was not expected. When? So let's say maybe financial. I put item number 21. Yes. Petitioner have informed us that they are not available. They are not? They are not available. They are not available today. You mean the petitioner's counsel is not available? Yes, sir. Here for the respondent. I'm appearing on behalf of the Jalan. So if matter be listed after the. Okay, what is your name? N. Bordoloy. Mr. N. Bordoloy, learned counsel appearing on behalf of Mr. G. Jalan, learned counsel for the SBI. Submits that they have been informed by the counsels for the petitioner that they would not be appearing in the court today due to personal difficulties. Accordingly, leave this matter after. Are you sure? I hope it's leave the matter after. Actually, you should not be doing this. Somebody else should be doing it, not the respondent. Anyway, accordingly, this matter after the petition.
What's the content of the other side with to mention item number 31, 32, and 30.
Yes.
The respondent has filed their affidavit because I want to file our reply matter. Kindly allow me.
Yes. Your father? Respondent to law. Another. For another law. So any objection? No. Okay, right. Miss Mrs. R. Begum, that counsel for the petitioner is granted 2 weeks time to file reply affidavit.
Reply.
When is the matter? 9, 10.
Item number 32.
Interim order passed in WPC 2961/2022. Can continue till the next day. Hello, okay. One more pair, madam. In respect of item number 42. Hello, respondent has filed objection, madam. We have to reply, madam. You have to file reply. Right. Your father? Mr. D. Gogoi, learned counsel for the petitioner is granted. 2 weeks time to file reply affidavit. This is the matter of the police. My pleasure. Interim order to continue till the next. Item number 7, my lord. Yes. In this matter, my lord, the petitioner is supposed to engage senior counsel. So, my lord, matter may be taken on Monday. Okay, right. On the prayer for adjournment made on behalf of Mr. H.A. Ahmed. You have Mr. H.A. Ahmed. Okay, on made by Mr. H.A. Ahmed. Learned counsel for the petition. This is the matter on Monday.
No, Lord, I like to mention item number 6, right?
Yes,
And agenda is for today, so you can have it out of six.
okay, right. Adjournment prayer has been made on behalf of Mr. Yukena on the ground that he is out of station. This is the matter on Monday.
Okay. So I like to mention item number 5.
Yes.
For adjournment for the
Your father?
additional.
No, you wait. 5.
Yes, sir. 5.
No, you wait.
Item number 14.
40?
3.
Yes, what about it?
You kindly take up the matter.
5?
Also, there's some inconvenience on our part.
Huh?
There's some inconvenience on our part.
Adjournment prayer has been made on behalf of Mr.
N. Gautam also could have been.
Huh?
Mr. N. Gautam.
N?
Gautam.
Okay, you're Mr. N. Gautam.
Sure.
Your name is not here. Can it be on behalf of you? Adjournment prayer has been made by Mr. N. Gautam on behalf of Mr. K. Chowdhury. Learned senior counsel. According to this matter, wait, in the next week.
In item 14, madam, which matter you wrote. At page 6, para 2, I had made a typographical error. It also had been lot number 2, I had written lot number 4. May I have permission to correct it? Small event, I made the correct information in all the errors, just on para 2.
The problem is, Mr. Counsel, it's not that we don't allow. We'll allow you, but after you file an application and you submit a proper, or we can, without filing an application also, we can ask you to, but you have to file a proper corrected fee. The reason being that when we allow you to do it by hand, that does not get reflected in the CIS, when it is uploaded. So there has been a notification issued by the High Court that whenever an amendment has to be made to the petition, application has to be made, has to be allowed, it will be allowed, and thereafter the proper corrected page or the corrected petition, amended petition would have to be filed. So that, because that will again have to be approved. That is the only reason, not that we don't allow.
It's a matter of one digit number. Right? 4 to 1.
What to do? But in the
I
computer,
have not made that error anywhere else, just that error.
what to do? Maybe what to do? The problem is now what you're doing by hand here, that will not be reflected because that has already been uploaded in the CIS system. So they have to make a change in the CIS.
Well, that's it.
This is item number 14.
14.
Anyway, you just wait. Just wait.
Hello, please. We will see you. I'd like to mention item number 22, your Lord.
Item 22. Yes,
In this matter, we need some time to file our rejoinder.
Mr.
Hey, that.
Who's on the other side? Petitioner. Have you spoken to the petitioner?
Respond, I am for the petitioner, your Lord. We have taken consent yesterday itself. We have submitted our
Okay, you're for the petitioner. So you want to file, what do you want to file?
rejoinder.
Okay, Mr.
Hey, that.
A Das appearing appearing for the petitioner. Is granted
2 weeks time.
2 weeks time to file rejoinder affidavit. This is the matter of it.
May I please mention item number 13, matter
13.
13.
Yes.
Couldn't meet for today only.
Huh?
I couldn't meet for today.
Why?
My I could not prepare the case, PD.
There is only one issue. Your regularization.
Yes,
Is it personal to your post?
ma'am.
End of the matter. That is why you want adjournment. And that is, you wait. No adjournment, you wait.
It is a lordship. The lordship, I beg to mention item number 47, lordship. I'm for the respondent, lordship. On behalf of Mr. P.J. Saikya, lordship. There's some difficulty to the lordship. Then the matter.
On behalf of Mr. Okay. Who's for the government of Assam? For the petitioner, review petition.
Lordship, I have contacted him. But lordship, he says they have returned the brief, lordship. I don't know who's there.
When do you want this matter?
Next week, lordship.
Right, on the prayer for adjournment made on behalf of Mr. PJ Saiki, then counsel for the respondent, this is the matter in the next. This is
Obliged,
the matter after the week. It's after.
obliged, Lord.
Dr. If I take mention item number 24, you're talking.
24.
Dr. We need some time to find my reply to you. I will say they have 5 minutes.
Yeah, for the
After the case.
Mr. P. O. Mr. L. Mohan, then counsel for the petition is granted. Give his time to find affidavit. This is the matter of three.
Doctor, may I pay for upgrading of item 65, F2, navigation of F2 €.
Why?
The content may carry out some size, but has not changed the.
No, there are other matters, Mr. Counsel. You wait your turn.
Okay.
You wait your turn. You wait your turn. Yes. What is your case?
It is related to correction of certificate, correction of the age in the certificate issued
By the,
SEPA,
Ah.
secondary board.
what is to be done?
My lord, he approached the Seva, my lord, after 48 years of the.
After 48 years.
time,
And what
asking-
has SEBA done?
My lord, they.
Has it allowed the
No, my
correction
lord, that has been rejected.
and rejected?
Yes, yes.
Then what
So-
remains?
So this, the rejection I am telling. On the basis that the Supreme Court of India has held that the limitation period is coterminous with the period of preservation of the records.
Huh?
By the court. Is coextensive with the period of preservation of the records by the court. In a similar case, dealing with
No,
the
no.
perimeter provisions.
No,
of the-
that doesn't mean that your petition has to be allowed.
And my lord, he is working as a medical officer, my lord.
Huh?
He is presently serving as a medical officer, my lord.
Okay, so,
And he's as date of termination at the age of 65, my lord, and he approached at the fag end of the service period.
oh, then there's Supreme Court judgment that you cannot challenge.
And my lord, on that judgment is. And he has not made the necessary party, my lord.
Who?
Health department.
I have not any problems with the health department because my
He
age,
is serving as a
my
medical officer.
age in the service record is as per my admit card. And I have furnished the provisional school certificate. I have not furnished the board certificate. It is only the board certificate that has the wrong age.
When are you supposed to retire?
I made that 63, 2 years, less than 2 years.
When are you going to, when is that, according to you, when were you born?
1/1/1960.
1/1/1960.
Right.
And according to the service record, what is the date of birth?
This is 1/1/1960. There is no problem with the service record.
Then
Only the problem is with my board certificate issued by the SEPA.
board
Of
certificate
my
says,
HSLC examination.
board certificate says what? That you were born on
On for 1 year later, 1 year,
1/1/1961.
no, what, yes, 1/1/59, 1/1/1959.
59.
So
So,
the admit
so,
card issued by the
so
board,
there is no problem with when you're going to retire.
yes, there is no problem. There is no problem, because this is the certificate issued by the board, and I have joined my services.
So,
By-
so you are going to retire on 1/19/2025,
Yes, right.
correct?
Yes.
On not on 1/34, I think 31/12 actually. 31/12/2004, 24 you'll retire. So even if it is changed, your date of birth is changed by the board
Yes.
to 1960.
Yes.
There'll be no effect.
Effective
your
my
service.
service. But it is the vital record of certificate that having wrong age. That's why I needed correct.
So it doesn't affect his
And
service at all.
and the admit card issued
My
by
lord,
the same.
notice may issue to file our.
Very soon.
Why?
Heard Mr.
All,
A. Laskar.
all,
O.
Yeah.
O
O.
for
Poliullah.
O. Laskar, learned counsel for the petitioner who submits that the petitioner's date of birth as recorded in his service book is 1/1/1960. And he would accordingly be retiring from service on 31/12/2024. Full stop. However, the petitioner's date of birth has been wrongly recorded in the Matriculation certificate.
Admit card,
In the-
Endurance
Not admit
certificate.
card, matriculation certificate issued by the. board.
Matriculation certificate issued by SEBA.
Yes.
Wherein it has been recorded as 1/1/1959. Full stop. He submits that the correction sought for by the petitioner has been rejected by SEBA. Full stop. He also submits that even if there is a correction to his date of birth by SEBA to 1/1/1960, the petitioner's retirement date as would in any event be 31/12/2024. Full stop. Issue notice returnable in 4 weeks, Mr.
DK Roy.
Huh?
DK Roy.
D.K. Roy. D for Delhi.
Yes,
D for Delhi. D.K. Roy, learn counsel for
Seva Bhai.
respondents. Number 1 to 4. One, no, 1 to 1, 1
One,
to
two,
3,
and three.
1, 2, and 3. Except notice on behalf of respondent 1 to and 3. What about inspector of school, setup, education department? Is it education what?
Yes.
Who is the council? Madam, inspector of school, who? No one? Who? P?
SMT 16.
Who?
SMT 16, secondary.
Mr. SMT 60, except notice on behalf of respondent number 4. Who sub petition takes step for service of notice upon the respondent number 5 by registered post with AD within 3 days. List the matter after 4 weeks.
The extra booking will be
Oblige.
Yes, Mrs. Madam.
Names were forwarded, Lordship, but the directors have chosen the present respondent, Lordship,
Who is which respondent?
private respondent
By?
for the court.
Initially, the selection committee appointed Dipali Kumar.
Yes, who relinquished.
Dipali Kumar is number 1.
Yes, number.
In the post of in so, but she relinquished and she did not join. The project level selection to review decide to send the names again to the same person, namely Karabi in her letters letter Dipali Kumar. Wife for but what is the ground? No ground, that's all.
Lordship.
So we'll set aside.
Yes, your Lordship is.
Huh?
If no
That's
other-
it. Right. Heard, Mr.
M. Ahmed.
M. Amit, learned counsel for the petitioner. And Miss M. Bhattacharya, learned counsel for the social welfare department. Full stop. The petitioner's case, in brief, is that the petitioner had taken part in the selection process for appointment of an Anganwadi helper in person to advertisement dated 29/12/2021. For helper or worker, which one?
Helper, Lordship.
Helper.
Help.
The person who secured the first position in the merit list declined to join the post of helper. And as such, the petitioner was expecting to be appointed to the said post. However, the state respondent appointed the respondent number 5, who secured the third position in the merit list, instead of the petitioner who had secured the second position in the merit list. Good stuff. Next para, Miss M. Bhattacharjee, the learned counsel for the Social Welfare Department, has submitted letter number CDPO bracket KPR bracket close E/1/95/PT Roman 4 dated 21/9/2023, which states that the which states that one Dipali Kumar had been appointed as Anganwadi helper in 2 number Dimu Kumar Subha Anganwadi Center on the basis of merit and as per the selection guideline. Full stop. However, Dipali Kumar did not join the force. Full stop. Thereafter, the project level selection committee, through a review cum re-verification on 16/12/22, decided to send the names of the petitioner who had secured the second position and the respondent number 5 who had secured the third position for the approval of the Director, Women and Child Development. Full stop. Thereafter, a letter dated 19/5/2023 was received from the Directorate of Women and Child Development, wherein the candidature of the respondent number 5 was approved for the post of Anganwadi helper. The letter also states that the respondent number 5 had secured the third position as per the approval of the selection committee. Next paragraph. The contents of the letter dated 21/9/2023 issued by the CDPO Kamalpur, what is this, Rangya ICDS, huh? Kamalpur Rangyas ICDS project is as follows. Take it out. No, before that is made a part of the record and marked as NHA. Okay. The the contents of the same is as follows. Okay. From here to here. Okay. A perusal of the above letter dated 21/9/2023 clearly shows that there is no dispute with regard to the fact that the petitioner had secured the second position in the merit list and that the respondent number 5 had secured the third position in the merit list. As the person who had secured the first position in the merit list had decided not to join the post of Anganwadi helper, it was incumbent on the state respondents to have appointed the respondent number, the petitioner, as she was next in line in the merit. No reasons have been given in the letter dated 21/9/2023 for appointing the respondent number 5 in lieu of the petition. The petitioner having secured a better position in the selection process for appointment to the post of Anganwadi helper. The appointment of the approval given by the approval given by the Directorate of Women and Child Development for appointment of the respondent number 5 over and above the respondent number 5, in the absence of any reason for doing the same, is arbitrary and violative of Article 14 of the Constitution. According, is there any appointment order issued? Is there any appointment order issued?
Yes, yes, not appointment letter,
Just approval?
Yes.
Where is the impugned order?
case number, my lord, 36, my lord.
No, 36 is your thing. Accordingly, the approval given by the Directorate of Women and Child Development for appointment of the respondent number 5 as Anganwadi helper.
Okay.
And any further consequential order passed in pursuance to the same is hereby set aside. The
My lord, that was 38, my lord. That's the appointment.
the state respondents are directed to appoint appoint the petitioner as Anganwadi helper in respect of 2 number Dimu Kumar Suba AWC within a period of 1 week from the date of receipt of a copy of this order. Consequently, the letter number CDPO bracket KPR /E-1 /part 2017 /641 dated 30/5/2023 issued by the respondent number 4 is hereby set aside. That is at page 38. Alright.
Wait, wait. For matter potential and non-payment of family plan and the compensation of pension.
When did you join?
My lord, I have joined in the year my 1994
As what?
as PM
And you
and died in harness on my lord 20 on my lord 11/2/2020.
you're regular plan. So beside, you've been giving GPF only.
Fine.
Okay, right. Heard Mr. PJ Saikia, Learned Counsel for the petitioner, that the petitioner was appointed as a peon in the office of the respondent number 5 on 7/4/1994. Petitioner's husband, huh? The petitioner's husband died in harness on
2/11
when?
11/2/20.
11/2/22.
Lordship,
11
Lordship, regarding so for annexer 2, it is stated that it is temporary office. The regulation, the order was.
Page-
on annexation.
page
Page
18.
18, Lordship.
okay.
Temporary office.
Against leave vacancy. It is against the leave vacancy, Mr. Counselor.
Page 18 my lord and
Yeah.
then 19 my lord. This terms of office peon is hereby granted. I'm sorry,
Concerned
page
leave
18, my
period.
lord.
Yes.
On the recommendation of selection committee. The undersigned page 18
894.
is appointed so and so on so and so.
Hmm,
Temporary
right.
office peon in the scale of
Died on census, huh?
It is stated that, the son of so and so, that the district so and so, the temporary as an office peon, ITI Nagaon in the salaries of so and so plus other allowances.
next page,
as-
page 18, madam.
18 is, 18, I am reading 18 only. 18, it is stated he is a temporary appointed.
On the recommendation of the
Yes,
selection. committee.
Maybe on the recommendation.
My lord.
So
But temporary,
temporary
the word temporary
appointment.
is there.
I'm serving my lord, they have issued certificate. to their-
Whatsoever, but you have no. Yes, sir, let him produce the regulation order. But he is not annexed here. Otherwise, we have to go to instruction, but,
Let them take instruction.
no,
my lord.
instruction should be come from the Industrial Training Institute also, not,
ITI Nagaon.
Yes, notice should be issued again.
Industrial Training Institute. This
Yes.
is under which department?
Lordship, this is,
Labor and employment.
although, but, this is, autonomous body, Lordship, institute.
Is it an autonomous body?
No. But parent department is the labor department, Lordship, but the instruction
No,
should
no,
come
Anyway,
from
right.
them, Lordship.
The
Instruction
petitioner's
should come
counsel
from
submits that the petitioner has not received any retirement, has not received any
Post retirement.
Huh?
Post retirement service.
has not received any retirement benefit except for the GPF. Issue notice returnable in 4 weeks. Mr.
J.K. Goswami.
J.K. Goswami accept notice on behalf of
1 and 2, Lordship. 1 and 2 and 3, Lordship.
1, 2, 3.
Yes, Lordship.
Mr. A. Hassan accept notice on the respond number 4. Petitioner takes step for service of notice upon the respond number 5 by registered secretary within 3 days. This is the matter.
Alright.
Extra provision.
Applicable. Whether this case leads to the approval of the FLC, my lord, on the pretext of my lord, 3 years remaining service, my lord, my case was not.
Where is that?
MP order, lordship will see at page operative part SP is 39. Last paragraph.
Yes.
After examining the proposal, committee did not recommend the same, so I'm not concerned with that one. And as he did not fulfill well, so the other part, however, the case of the Srimati so and so is deferred in view of the judgment and order dated so and so passed by the Honorable High Court so and so. Now that judgment lordship will be,
No, but where is the rejection of a candidate?
my
There's no
lord,
rejection.
deferred, my lord, indefinitely.
So, no,
Have to
no.
take a decision in the light of the
Okay.
decision has already.
Have
been-
you, huh?
That.
Decision
judgment,
has
my
been
lord,
taken. Huh?
already been there.
In view
decided.
of the judgment and order, sir. Yes, madam.
Lordship, this has been recommended by the DLC only. This was not placed before the SLC.
SLC.
Without putting before the SLC, they have appointed the petitioner lordship. This is there. And yes,
No, no, no.
lordship, now they have referred to SLC where SLC has observed.
No, now SLC, did the SLC take a decision?
Yes, after the petitioner was appointed,
Doesn't matter.
lordship, and that too, the judgment they are referring lordship, this is already put to challenge lordship. This is subjudiced before the division bench. The order, the common judgment and order lordship.
Oh.
This is already put to challenge.
So you're working right now.
Working, my lord.
Well, huh?
Working,
Then why you filing a case?
my lord, I'm not getting salary, man. Oh, for the want of this, they kept effort. SLC kept effort. The 3 years has been strike off by the honorable single judge. And I.
Has it been stayed? The
No.
judgment has it been stayed?
No,
Then take a decision. Otherwise, if he's working, you give him his pay.
Lordship, this is the.
Yes, Madam Kemprai,
PhD.
give the pay. Huh?
Page 38. Well, SLC is rejected, sir.
Not rejected.
SLC is rejected where?
Page 38, sir.
38, yes, I've got it. Where is the
The
rejection?
committee carefully examined all the relevant particular findings by the tribunal, recommendation DSC for appointment of committee. Brown included focus upon verification. The committee observed that he so and so. He got his last line, Lordship, he got his provision certificate from money. But his salary is the one of the.
Only salary stop. His application is not rejected.
Right.
Yes,
Lordship, the matter is after that, there was delay condom, Mr. Lordship. Delay has already been condom. And Lordship has directed that separate applications have to be, appeal has to be made. Lord. Because there is a bunch of cases has been such a common single order. Lord.
okay.
One is filed and others are Lordship filing, and this will also take together. Lord. The, this, part, this part has not happened.
No stay, nothing, but
Whatever it is, it's already accepted.
it
That
is
means
we are,
we have,
we are filing application under that. But
But what is to be done? We can't dispose it off straight away.
or Lordship, Lordship asked them to may pay my salary and Lordship.
You pay the salary, madam. Since he's working, you have appointed him. The appointment order has not been set aside, not cancelled, correct?
No.
Lordship, the last paragraph of page 39, Lordship, that says,
Yes.
after examining the proposal, the committee did not recommend the case of chief Porcentino as it did not fulfill the criteria.
I'm not forcing it, but ma'am,
But
he's not reading my.
She's not, she's not
Oh.
forcing.
relapse
Forcing is different. Forcing is the male. The last C line. However, the case of so and so is different. In view of the judgment order.
in case of Srimati Reena Singh Dwara Lordship, it is seen that for making application for a compulsory appointment, provided in each case the government servant has balanced a minimum of 3 years of service. Sir. That-
But then the judgment has set aside that. Anyway, right. Heard Mr. Jay Barbuya, learned counsel for the petitioner who submits that the petitioner's application for compassionate appointment had been recommended by the TLC, which resulted in the petitioner being given an appointment order as peon, correct?
Yes,
On compassionate ground by letter dated,
page 35, madam, 25-1.
by order dated 25/1/2021.
Right.
Issued by the District Deputy Registrar of Cooperative Societies, Karbi Anglo, thereafter,
But like approval by the district level committee, by the district councillor.
the said order of appointment had been made after approval had been given to the district level TLC recommendation by the district council. Subsequent to the above facts, the petitioner's application for compassionate appointment along with the DLC recommendation was sent to the SLC
Right.
for consideration. Full stop.
For approval.
For approval. Full stop. The SLC in its meeting minutes dated 2/3/23 deferred the deferred considering the case of the petitioner on the ground that the mother-in-law of the petitioner did not have a balance of a minimum of 3 years of service at the time she died. And as such, could not have been given compassionate appointment in terms of clause 1 of the OM dated 1/6/2015. This court, in its judgment and order dated 30/01/2023, passed in WPC 1646/2021, held that
Page 90, para 19, page 85.
page
Page 85, para 90.
held that clause 1 of the OM dated 1/6/2015, whereby the dependent family members of a government official who dies in harness, having less than the minimum 3 years of service, were not eligible to be appointed on compassionate basis, was declared to be unconstitutional, being violative of Article 40. Clause 1 of the OM dated 1/6/2015 was accordingly set aside. Was accordingly struck down. Accordingly struck down. The petitioner's counsel thus praised that the case of the petitioner should be considered by the SLC at the earliest. As earliest, full stop. Next part. Miss S. Kemprai appearing for
Respondent number 5 and
respondent number 5 and 6, and Miss M. Bhattacharjee appearing for respondent numbers
1 and 4.
1 and 4. Acha, and you got the name? Why what? A. Konyak. Why A. Konyak? Why A. Konyak appearing on behalf of M.D. Bora for respondent number 2, and Miss and Mr. R.M. Miss R.M. Barwa appearing for Mr. A. Chaliha for respondent number 3. Submit that the judgment and order dated 30/01/23 passed in WPC 1646 of 2021 has been put to challenge in WA number
Not
I
yet,
shall provide that.
but whatever my inspection is that whether it's not yet been numbered.
Huh?
Not yet been numbered, because the initial case 3 years I challenged over, but I have not.
what is the number? Huh? Yes. Yes. 257 of 2023. Then what to do?
Salary part minor, at least I am widow, my lord.
Huh?
I am widow having one minor son. Very difficult minor, no one is there. Salary part minor,
Next para. And before the petition, before the respondent, the petitioner's counsel submit that the respondents have stopped paying the salary of the petitioner since
since my lordship kindly turn to page 39. From August, my lord,
from August
August 21.
2021. Though the petitioner is still working in the office of the
Office of the Assistant Register Cooperative Society.
deputy registrar or assistant registrar?
Deputy Registrar.
Deputy registrar of cooperative societies from a Karbi Anglong.
Assistant Registrar.
as
Extend or lordship can,
actually deputy assistant slash deputy. Assistant slash deputy. As no, first of all, if the next para, if the petitioner is still found to be working in the office of the assistant slash deputy registrar of corporate societies, Karbiangalang district, the petitioner would have to be paid his salary on the principle of quantum merit. Accordingly, the state respondents shall take steps to pay the salary of the petitioner in the meantime. If he is found, if the petitioner is found to have worked from August 2021 onward. This is the matter after 4 weeks to enable the respondents to obtain this.
it may be matter for paying the
Lordship, it-
Okay, okay, yeah. Yeah, we have already issued notice, no, okay, before they say issue notice, returnable in 4 weeks, then they will accept notice, huh? Those names.
And the salary may be released within 2 weeks, 3 weeks, might. Otherwise, matter not.
It will come.
Some date matter 2 weeks,
It will come, it will,
or month, 80 day matter, because I'm surviving with video my, no one, only one, sir. No one has to take care of it.
let's see. Next.
May I please? May I please? I'm paying for adjournment for the deal.
Right?
I think from next week, Lordship.
You see one thing,
Lordship.
let us see a prayer. Your prayer is to set aside and quiet the DLC minute of 2016.
Yes.
You are coming after 7 years. Why should we allow on this ground? Where I'm dismissing it on this ground.
With the paragraph 16 of my bill. Lordship.
Yes,
But may I read?
yes.
That the petitioner basically state that these being replaced since the date of application, she was continuously approaching the concerned authority. And in several occasions, she was visited the office of the respondent authority, but till the year of 2017, the impugned rejection order dated 24/6/2016 has not been communicated to her. The petitioner came only in the year of 2018 when visited the office, and thereafter due to COVID-19 pandemic and poverty, she could not able to challenge the state order immediately. However, on 17/2022, the elder daughter of the petitioner filed an application before the office of the respondent number 3 and sent the copy of the chief minister of Assam, chief engineer of the irrigation department of the government of Assam, and executive engineer Nolbari within bracket irrigation, wherein she paid for considering her name for the appointment of compassionate ground in the post of her father. So this is my I have
You
continued
came to know in the year 2018
18.
and still and now it's 23
Yes.
September.
Yes.
So you have taken 5 years to challenge.
In detail, there is a.
Yes, no, yeah. Huh?
Pending it is.
And then not only that, actually,
Yes.
you have given up your claim because now your daughter has filed. But your daughter's claim is after 1 year.
But if, my prayer is looking not only for daughter, but if.
No case, Mr. Counsel.
Fix a date, Lordship. My
No,
senior-
I've heard you.
Lordship, my senior will appear in this.
I've heard you.
Lordship, my senior will appear, Lordship. Fix a date, Lordship, on any day, Lordship.
What is your name?
Lordship, take care of Lordship.
Huh?
Take care of Lordship. Lordship, my senior duty will appear in this case, Lordship, may give a date, Lordship. On that day, he will appear.
Heard
Once
Mr.
out, Lordship, but I.
Heard Mr. A.K. Azad, learned counsel for the petitioner.
I am paying for one Sunday.
This matter pertains to the prayer of the petitioner. You see one thing. You are praying for your daughter. Your daughter is not a party here.
Lordship,
Your daughter is not even a party here.
why I am not paying for daughter, Lordship.
You are praying for a daughter. You are saying here to
What
recommend
application she was submitted before?
to recommend either the
Now,
name
in
of the
the-
petitioner or the
Petition, Lordship, myself.
right. Heard Mr. AKR, Leonard Counsel for the petition. Who submits that the petitioner's husband, who was working as a khalashi in the office of the executive engineer Nalbari, comma, irrigation, comma, died in harness on 28/9/2030,
Okay, paragraph 13, Lordship.
leaving behind the petitioner along with 3 daughters. The petitioner submitted an application for compassionate appointment. The district level committee in its meeting minutes dated 25/7/2016 rejected the prayer of the petitioner for compassionate appointment on the ground that the petitioner's application has lost its force as the no due to the total cadre strength man in due to the no due to the 5%. No, due to the total cadre strength / man in position. No. What is this? Where is the
Lordship, see the page 31, Lordship, I have annexed the office memorandum, Lordship. Clause 15, Lordship. Right, stated, Lordship, about this.
just a minute, Mr. Counsel, please. Enough. No, before that. On the ground that 5% of the total cadre strength / man in position for appointment on compassionate grounds did not allow for consideration of the application as it had completed 2 years in terms of the government office memorandum. Minister. The further case of the petitioner is that the petitioner came to know of the rejection of her application for compassionate appointment only in the year 2018. Thereafter, the elder daughter of the petitioner filed an application for compassionate appointment on 17/2/2020. the petitioner's case, the petitioner's prayer in this writ petition is for a direction to be issued. No, is for a the petition prayer is petition is to set aside and quash the DLC meeting minutes dated 24/6/2016, rejecting the application for rejecting the petitioner's application for compassionate appointment, and to recommend either the name of the petitioner or her daughter for appointment on compassionate terms. Next one. A perusal of the pleadings shows that only the petitioner has approached this court, and the daughter of the petitioner is not before this court. And that's such. The prayer for consideration of her daughter's case does not arise. Next part. With regard to the petitioner's application for compassionate appointment, it is seen that the petitioner's application had been rejected in the year 2016, and the petitioner came to know of the same in the year 2018. The DLC meeting minutes implies that, no, shows that due to, implies that due to the man in position in respect of the 5 quota percent reserved for compassionate appointment did not allow for the petitioner's application to be considered. The petitioner's application for compassionate appointment to be considered within 2 years from the date of submission of the petitioner's application. Next paragraph. In the case of Achyut Ranjan Das versus State of Assam, reported in 2006 whatever. This court has held at clause 10, I think, as follows. Next. In the present case, there is no averment made by the petitioner that there were vacancies available for consideration of the petitioner's case for compassionate appointment. And as such,
If I have mentioned in my petition, in paragraph 15,
15.
yes, in respect of vacancy, whether, other or not.
No, you just said many persons were appointed. Full stop.
Yes.
Full
Uh,
stop.
the clause 15 of office memorandum, which is a party dealer.
This is not your prayer. Your clause 15. It is not in your prayer.
The post is not, the second is not available, but if the department can, discuss with other departments.
Mr. Council, you should come at the earliest. You cannot come after 4, 5, 6 years, 7 years. You cannot come.
I'm elaborate.
Next, whatever I said. Dismiss. Next.
I'm sorry, Lord. I'm sorry, Lord.
No, I'll give you the tip. Yes,
Regarding related to the content of peon, the service of began just couple. There was an advertisement, but if I may take a lot to the advertisement.
yes,
Advertisement at page 23.
yes,
Here, my lord will see that for the post of peon, there were 3 posts, my lord.
yes,
One each for ST planes, one for ST hills, and one for persons with disability. The petitioner is a person with disability. I connected certificate. Here, 48%.
then,
Yes. Thereafter, my lord, a electric was prepared, my lord. At page 26 for the fiber optic.
yes, then,
The petitioner was selected, my lord. Thereafter, my lord, the select list was published, my lord, at page 38.
yes,
At serial number 3, my lord, we will see against the post under the category of persons with disability,
yes,
one Monumita Rabha has been selected.
at, page number
38. 38.
23.
38.
Rabba, yes,
Now, my lord, this Monumita Rabha, my lord, here in the private respondent, my lord, she applied
respondent number,
respondent number 4.
yes,
She applied for the post under the category of ST planes. Page 27.
okay,
Page 27, serial number 6.
Ah.
She applied for the post of peon under the category of
but
ST
she has
planes.
been given under
She has
penalty.
been given under,
She has been appointed.
she has been appointed.
Where is the,
Appointment letter is not annexed, my lord.
why?
The select list is here.
So has she been appointed or not?
See, I'm being told, my lord, she has been appointed. I have
Anyway, that will,
Lord,
Yes.
High Court is a necessary party there. They have not.
why is High Court a necessary part?
appointing authority is district and session judge.
Why is High Court a necessary part?
Standing council of it, which is session that and
Huh?
session that selection committees presented by standing council. And the corpus also their name has not been.
Why is the High Court a necessary part?
Appointing authority is the district and
Anyway, right. Heard, Mr.
PK Munir.
P.K. Munir, learned counsel for the petitioner who submit that in the advertisement dated 10/3/2023. Applications have been called for filling up the post of peon. For the filling up of 3 posts of peon, which were to be filled up by the following category of persons. That is STP -1, 1 post, SPH 1 post, and PWD 1 post. What's up? The petitioner's counsel submits that the respondent number 4, who had applied for the post of peer as an STP candidate, ST bracket P candidate, has been selected as the peon as in the PWD category. So in this regard, he has referred to the name of respondent number 4 being reflected at serial number 6, serial number 6 of the
So candidate inside.
in the serial number 6 of the list of candidates at serial number in page 27. juxtaposed with the juxtaposed with serial number 3 in the notification dated 9/8/2023, bracket page 38. Issue notice returnable in 4 weeks. Who is for the state of Assam? LR, you are Ms. A. Talukdar accept notice on behalf of
One for others, there is checking.
for one. Petitioner takes steps for service of notice upon the respondents number 2, 3, and 4. By the court with AD within 3 days. This is the matter of the court.
Can there be observed that the appointment of reference number?
The appointment of the respondent number 4 shall be subject to the outcome of the request.
Obliged.
Under this case, this is to the special investment price for physically active person.
Where is the,
The advertisement was issued, my lord, accordingly I participate, I got.
where is the advertisement?
Advertisement. Got. Lordship will see page 34 one. Operative part is for
34?
Four.
Advertisement dated 30/12/18.
yes, different types of
Now,
my lord.
you-
Department was there, my lord,
Uh,
and as per and I am concerned with the social conservation department, page 4 post at page 40. Thereafter, my lord.
Yes, 7. Page 40, which one?
the Social plus my lord,
Soil conservation,
soil conservation,
which post?
page 4.
No. Wait for, there is plantation Mali, there
My
is
lord,
Karachi,
It is.
Grade 4
mentioned as
post.
the only
Okay.
grade 4.
grade 4.
Great. Then, my lord, I was issued a call
This
letter,
is for PWD.
all PW.
Okay.
Then I was issued a call letter at page 53, my, giving me 3 options,
Page 53,
plotting. It's the call letter.
all letter,
Call letter, my lord, they fix, my lord, my disability impaired.
all letter dated
Call letter dated, my lord, lordship would be. It is not mentioned.
Okay.
Then I.
All
have been-
letter is where you
then
have to
got
go
one thing,
on
my lord.
27/2/21. Okay, then
Preferred department, I've been given, my lord. Lordship will see the page 50.
Huh?
Page 53.
yes, 53.
My lord, preferred department, lordship has come across.
Ah,
3 department was
okay.
water resources, soil conservation, animal husbandry. Thereafter, my lord, in the meantime, a read petition was initiated by some other persons, my lord. Accordingly, it was paid. Thereafter, my lord, it has been directed to publish the list, my lord, by department one. Operative part, lordship will see
Page
page 108, operative 108.
yes,
Last paragraph. of it.
108 is the order.
Order, man. Initially, there was a stay, my lord.
Then 109 is the list.
My lord, that I'm coming now. Before that, my lord, the honorable food stage, my lord, by IA page 108, my lord, that department wise has to be published. Then, my lord, the concerned authority,
Where does it say? Where does it say?
my lord,
Where does the court say it has to be department wise?
my lord, is there, my lord, in lordship will see page 106. 2 pages also, my lord.
Yes.
In view of the limited prayer raised in the merit list, published under the manner is contrary to so, we direct the registry of body university to look into the spec for the matter and has to be prepared, whether department wise or general,
Whether department wise or in general.
or in
Doesn't say.
general. After examining the matter raised, registrar shall pass the revision order if necessary to do the rectification of the work that may be required under the law. Required to be done within a period of 7 days from the receipt of the certified copy. Till reason order is first raised, this has been published, shall not be acted on. Then, my lord, other person, they filed an IA. Then the honorable court says, my lord, page 108. Operative last paragraph, my lord, taking account into the submission and there being no objection from the opposite parties herein, this court allows the registered body university to comply with the direction and that being period given in paragraph 4 of the order dated applicant sent disposal. Then, my lord, selection list was published and my name appeared as 111, serial number 92.
Now this list has been made. How is it made? Is it made department wise or in general?
Department.
Where do you say, how do you say that department?
Page 94 is in. All the department page start from 109.
Huh?
Start from 109.
109, yeah.
10. And
so-
my is my lord at serial number 94. That is at page 111. What? 111.
111, yes, I've got 111.
Page serial number 94. Bottom, my lord.
This is 94, yes.
They have mentioned my roll number so and so. 12 conduct. 12 conduct. Thereafter, my lord,
Okay, department wise list of candidates prepared, okay.
I was selected for 12 conduct. Thereafter, my lord. Thereafter, my lord, I was in not appointed, my lord. A general notice was passed
Where?
at page 120.
122.
Well-
Yes,
There I have been asked to file an appeal.
so you did not qualify in the medical examination.
My lord, that I'm coming. Then Lord will see page 122. I have been asked to file appeal. Accordingly, I appeared, my lord, page 123.
So you filed an appeal, page
Page,
123, what
my
is
lord,
this?
Then, my lord, I have
What
been
is
asked
123?
123, my lord, those who have filed the appeal, they have been again asked for medical.
Okay,
So
so
my
you,
serial number is 117 at page 120.
117.
107.
Good.
Hospital comment, 107. Thereafter, my lord.
Yes.
Out of that, my lord, only 4 persons have been appointed. That is 120. After re-medical, my lord, only 4 persons have been appointed. That is 120.
So you have failed in the,
No, man, that I'm coming.
Yeah.
Then,
now this is what, another medical, then
my
four
lord,
persons appointed, then
my lord, others have been appointed, my lord. Then of my own, my lord, I went to the medical authorities for examination of the
where?
at page 121, my lord, it is been given and connection 9 at page 150.
121.
115, lord.
You went to the hospital.
My lord, of my own same medical board. And they have tested me, my lord, 116, 17, 18, 19, they have tested and they have given opinion, my lord, that your lordship would see at page 121.
121.
What about me?
Yes,
Medical history, my lord. DPA on 12th GMC 12th reported source of blind hearing was lost. Beta was done on 12th and reported as a relation monitoring severe hearing loss. And recommendation referred to the sort of by the strong class as to continue. Then they found me, I am blind, impaired. person. Then my lord.
Hearing impaired,
Impaired.
but you, when you file your application, you went in as what? As low, blind and low vision or by due to hearing impaired? Let us see how, what was the basis
Hearing.
for,
Hearing impaired.
hearing? Okay. Hearing impaired,
Then my lord, the 4% have been appointed, my lord. In the meantime, my lord, a decision has arisen in Aadhar High Court, my lord, Karnataka. Operative part,
this is an all India thing or something?
no.
No.
Take over.
State.
For reference, my lord, a subject matter was issued, my lord, whether doctor can, board, my lord, can express the confusion. Then operative part lordship kindly turn to page 128. There are four.
Yeah.
There are four. May I read, my? The moot question is whether the board could have expressed such conclusion and eligibility of the candidate to be concluded by the respondent. It is certainly not that within the domain of the medical board, being an expert body, it has merely required to assess the certify the extent of the disability. In our opinion, conclusion drawn by the board is unsustainable, illegal, and board is not directing authority in disability of the candidate cannot be certified by the board. It was held, my lord, that cannot do. Now, my lord, for the no reason, my lord, my appointment has not been issued, despite of having several back and forth.
No, you see. The question is, the medical examination, what was the percentage of your injury? I mean, the percentage of your hearing impairment? How much? 45%.
45.
So, what is the, how much percentage is the permissible limit?
That is not there, totally fine. 45 minutes without medicine, I cannot hear any.
No. So, let us see the PWD Act. What does the PWD Act say for hearing impairment? Yes, madam, anything?
Okay, I supplied the thing. Or not, it's a Sakila movie. Okay, mark for that.
Yes, which section?
My lord, I'm fine. Section, my lord, 33, my lord. It says, my lord, every appropriate government shall appoint in every establishment such percentage of the vacancy is not less than 3%. So blindness of the low vision, hearing strength. Otherwise, my lord, I do not find what is the benchmark method.
No, there has to be. There has to be.
But my lord, what is the,
Is it provided in the rule or what?
my lord, I did not find anywhere, my lord, what the state has may have. my
Lordship,
lord.
it may be there in the advertisement, but I'm looking.
Yeah. Let us see the advertisement.
Lord,
They have to
Page
be there.
34.
They have to be, they have to be.
Has to be somewhere, but it is not reflected. Yes, it is must be citizen of.
No,
Yes.
now, how many vacancies are there?
Vacancy, my lord, all over Assam, it was a special recruitment around above 700.
So it has
300 have been appointed already.
300. So there's still some vacancies.
The vacancy everywhere. And my lord, what is the benchmark where they get, my lord? And other petition also will see 50% is also.
No, but what is this doctor certificate that you're talking about? How does it help you?
My lord, I have gone myself, my.
So,
Lordship, as per case number 35, Lordship,
yes,
it stated that OH, HH and EH may be considered if she can function with aids, appliances identified as per Social Welfare Department Government of Assam notification that is. So the notification,
where does it say?
Lordship,
Where does it say that? Where?
35, page number 35, Lordship,
35.
in the right side column, against the pharmacist technical or storekeeper technical, Lordship. The right side.
No, but we are not bothered with storekeeper. We are bothered with class 4. Anyway, I know you obtain instruction.
Lordship. Lordship,
What is to be done? Have you filed any representation? No.
No, but only my lord, my prayer with your lordship is that my lord, the respective post that cannot.
No. If there is 800 posts and 500 are still lying vacant or 400, why should we give you stay order?
Lordship, for the
There's no
social
ground.
welfare,
No, my lord, department wise they have taken.
Mr. Council, just now you said that 300 posts have been filled up out of
Yes, sir.
700 posts. So there are 400 posts. No problem.
Let
No
them
need
take-
of stay.
Let them take it back.
The
Lordship,
I heard Mr. J. Barbuya, learned counsel for the petitioner, who submits that the petitioner who had applied for a grade 4 post
but hearing
as a hearing impaired person under the persons with disabilities bracket equal opportunities, protection of rights and full participation bracket close Act 1995. Hereinafter referred to as the PWD Act of 1995. Has not been. I have taken part in the selection process in terms of, not pursuant to advertisement dated 30/12/2018. However, the petitioner has not been selected,
I got selected.
had been selected, but not appointed due to
Why there?
not appointed. Full stop. He submits that no explanation has been given as to why he has not been appointed.
the medical exam,
Due to disqualification in the medical.
medical exam.
Okay, whatever, then what, just read that before that. Comma, though it appears that he has been disqualified in the medical examination, comma, without elaborating on the same. Issue notice returnable in 4 weeks. Miss A. Talukdar accepts notice on behalf of
One on the Lordship.
1.
But 2 and 3 they are standing up, 2, 3 and 4.
Who is the standing counsel? 2 cannot be standing counsel. Who is 2? Social justice and empowerment. Who is 2?
Lordship.
Who? You?
GM, my
No,
lord,
no.
government of.
RM Das.
RM Das.
Mr. R.M. Das accepts notice on behalf of point number 2. What about? Acha, 2 and 3, I think R.M. Das.
2, 3 and 4, Lordship.
2, 3 and 4 R.M. Das. Huh? And then
Maybe also.
Mr. P.J. Fukan accepts notice on behalf of point number 5. What about 7 and 8?
My lord, I am appearing for 7 and 8.
Mr. D.P. Bora accepts notice on behalf of point number 7. This is the matter of the 4 weeks.
My lord,
Enable the
our
report.
name has not been shown, my lord. SK Health.
And that.
This is the matter of the 4 weeks. To enable the respondents not to obtain effective. Registry to reflect ST
Health and Family Welfare.
And social welfare.
health and social welfare
Justice, Lordship.
in the causes.
Social
ST
justice,
Health and Family Welfare and ST.
social justice and empowerment.
ST Health and Family Welfare. And ST Social Justice and Empowerment.
one of the different any
Not any,
shall be outcome of that.
what, any?
Any, my lord, they are going to recruit or somebody else, my lord. That's
No.
Yes.
My lord, 10, 11, 10, 11.
10 is with regard to what?
My
Wait,
lord,
wait,
I'll
wait.
just tell my lord, 10 is regard to the blind.
10 is 10, yeah, out here is not hearing impaired, out here is blind and
Blind.
low vision. Blind
11
and low
is
vision, okay.
also blind,
11 also blind and low vision.
and 16 is hearing,
16 is hearing impairment, same as
17 is the blind.
9, huh? Then 17 is blind and low vision.
That's it, extra copy needed.
Yeah, I cannot.
He'll give it to you.
I have to give my lord, otherwise I cannot.
The appeal is pending, but the post is not as the GAD has taken over. So
Now the appeal is pending.
That's it.
So-
I'm appealing for the
Yeah.
department. Our name has not been shown. Just
No, anyway, basically, now the appeal has to be transferred to the commissioner.
that's what my lord, my
GAD, from CAD to GAD. From divisional commissioner to GAD.
Correct.
commissioner and secretary.
Where is that notification?
Yes, Lord. It is in the repetition.
It's in the written.
No, my,
No, no,
it is not in there.
in item number 15, Lordship. Item number.
Item 15. Just give me item.
Page
Just give me that.
page 72. Page 70.
So who will transfer it? He cannot transfer it. He is a petitioner. His office work so cannot be done. Then who will do it? Because as per this notification, the statutory powers, the assets of the existing divisional commissioner and the employees will come under the establishment of the district in which the headquarters of the divisional commissioner is presently located. So I think the deputy commissioner will have to be directed to do it.
Yes, for the files.
Is the deputy commissioner party here?
Yes, my lord. Deputy commissioner is party here. Well, appeal is pending before that.
No, the additional deputy commissioner. is a party. You have not made deputy commissioner.
Yes, my lord, I have made it.
Where?
No, my lord, four, that's my lord, four, my lord. The selection board represented by chairman, deputy commissioner. No.
That is selection board, Mr. Council. That is not deputy commissioner. Please understand the difference.
Here, my lord, the appeal is pending before the SCAT, my lord, PD.
I
Central
correct.
Administrative Tribunal, my lord, divisional, Central Administrative Tribunal,
Why should it be before central administrative?
because I filed appeal before the, my lord, divisional commissioner, Central Administrative Tribunal. This is the wrong term, but this is the wrong term. Say commissioner. Central Assembly Division. Central Assembly.
Exactly.
Not cap.
Sorry, madam. Central Assembly.
Lordship, that is automatic, Lordship, as part of file. for one.
No, but then we have got to pinpoint or fix the onus or the responsibility on a particular office to ensure that you see that it is sent to that.
To the deputy.
Deputy commissioner is not a party here, but okay, we say deputy commissioner and additional deputy commissioner
Lordship,
revenue. That will be sent. That is your case. Third, Mr. B. Raman, learned counsel for the petitioner, who submits that the petitioner had taken part in the selection process for filling up the post of Gaon Bura / Gaon Pradhan in respect of lot number 4 and 5, Kalia Dinga Farm, Kalia Dinga Gaon and Kathal Guti Isamat, Nagaon district in pursuant to advertisement dated 5/9/22. The respondent number 7, the appointment of the respondent number 7,
Selection.
the selection of the respondent number 7 as Gaon Bura / Gaon Pradhan for the aforesaid lot was put to challenge by the petitioner under the amended executive instruction 162C before the divisional commissioner, Central Assam Division,
No, okay.
Nagaon. He submits that in view of the abolishment of, in view of the offices of the divisional commissioners in the state being abolished, comma, the petitioner's appeal, which is registered as
As my lord, RRCAD 7.
RRCAD
CAD, okay, CAD 7/2023.
7/2023
And annexed here.
has come to a standstill. To stop. Next, Mr.
CKS 4,
TKS Barwa for
2, 4, 4, 5, 6.
2456, Mr.
Lordship, there is a very pattern thing. He has to go for amendment of his petition also, because here they have not been. In the area of respondents.
Doesn't matter. You don't come then. You want to be here or what? You're not a party.
So
then.
he has to bring the status of the appeal. Also.
No, he doesn't have to bring. We'll direct that it should go to this. That's all. That's all. We'll direct the deputy commissioner to place it before the GAD. That's all. Within a specified time period. And then he'll go and inquire. That's all. And Mr. There's that beautiful point number 1 and to submit that in terms of the notification, in terms of notification, the number e-file number, in terms of the in terms of notification e-file number 304149/1 dated 17/7/2023. The assets of the existing the assets of the abolished divisional commissioners establishment and the employees would come under the establishment of the district in which the headquarter of the divisional commissioner is located. Full stop. Further, the statutory powers and administrative powers exercised by the divisional commissioner will be exercised by the commissioner and secretary / principal secretary of general administration department. Full stop. Next. I have heard the learned counsel for the parties and perused the notification dated 17/7/23 issued by the principal secretary to the government of Assam from a general administration department, which is to the following effect. Just take it down, huh? From here to here. Okay. The said notification, the above notification shows that the appeal file by the petitioner against the selection of the respondent number 7 to the post of Gaunbura would have to be now decided by the commissioner secretary / principal secretary of the general administration department from a government of Assam. Accordingly, the deputy commissioner Nagaon and the additional deputy commissioner revenue from Assam shall immediately take steps to transmit the what is the case number?
Appeal number RR bracket
Appeal number RR
bracket CAD
bracket CAD
7/2023.
7/2023, which had been pending before the divisional commissioner central
Assam division.
Assam division, before the commissioner secretary / principal secretary of the general administration from a government of Assam, who shall thereafter dispose of the same in terms of the above notification. The deputy commissioner and additional deputy commissioner shall ensure that the records of the appeal mentioned above are brought to the office of the commissioner secretary / principal secretary of the general administration department within a period of 2 weeks from the date of receipt of a copy of this order. The writ petition is accordingly disposed of.
Yeah.
Thereafter, they will decide actually. We have not made them a party to give a direction of
14 and 15 are same.
14 and 15. But the number will be different.
Yes, the number.
In 14, what is the appeal
14 and
number?
15, I have made AD party, your lordship.
Huh?
Content number
Okay.
2.
No, what is the appeal number in 14?
RRCAT 42, 2023.
RRCAD 42, 2023. That, and 15,
RRCAT 43, 2020.
40, 20.
Your lordship, I have made an interim prayer, your lordship.
Oh,
In the disposal of the appeal, my lord. The appointment of respondent fixed might may be stayed, your lordship.
I can this is
I'll serve a
before
copy, my lord.
this is before that.
I'm for report number 2.
Okay, in item 14 and 15, let's see, the numbering might be changed. Mr. CK Hazarika for CK Barwa for
3-4.
345. Mr. For
For report number 2.
2 and Mr. S Data for 1. Okay,
My lord, Bhagwati, my lord,
it's finished. There's no need of reflection now.
Your lordship. My lord, record.
No stay, no stay. What?
My lord, till its disposal, my lord.
No. That you go pray
I
there.
enact a similar order, your lordship. where
No.
Please to consider, my
No,
lord.
no.
Your lordship may just enact, read the order, my lord. Page 82, your lordship. Page 82.
When an appeal is before some other court, how can we do it? It's not proper. If they, now the thing is that you go there, if they deny you your prayer, then you come here. That's a different issue.
Your lordship, the problem is the records are still there in the office, my lord.
So that is why we asked them to now do it within 2 weeks.
There's the some report I say.
Within 2 weeks, you make the submission before the secretary, GAD. If he doesn't allow, then you come here.
After 2 weeks, my lord, 15.
Huh?
Within 2 weeks, the records are supposed to go to respondent number 2, your lord.
Within 2 weeks of you furnishing an order
My lord.
to the deputy commissioner concerned, they are supposed to give it to the concerned office.
Right.
And thereafter you make your prayer. If your prayer is not answered therein, then you can come here. Otherwise, it would not be proper.
That observation is there, my lord, that I may have the liberty to spread this prayer, my lord.
That is always there. There is no bar.
All right.
You put that, huh? And you give him that, you give it. Item 13. Oh, I did not allow this. This is a regularization. He wanted adjournment. I did not allow. This regularization is personal.
Yes.
To the
it's
post.
only the person
Personal.
petitioner.
So he wants.
He wants promotion from grade 4 to grade
So,
3
so that is bad
also,
because of, I think, division bench judgment.
in the light of Dilip Talukar's
Yes. Can you- If they are not here, what to do? I'll make I will reflect that they have come and who was the council who came? Slightly bearded fellow. Item 13, na? Mr. B, what was his name? I forgot. AK Datta, na? Okay, right. No one appears for the petitioners. Though Mr. AK Datta, the learned counsel for the petitioners, had appeared in the morning, praying for adjournment of this case. The same not having been, the same was not allowed by this court. Miss
And Kalita
M. Kalita appears for
department also responded.
all the response. The petitioner's case is that where is the regularization order?
They have annexed their appointment letter. That is in page 32. They have mentioned in the synopsis itself that they have been regularized.
The petitioner's case is that they were initially engaged as Khalasi / peon in the public in health engineering department as master role worker. No, that's on master role basis. On master role basis. Thereafter, the petitioner's services were regularized by the government. Also. The council, Mr. A.K. Datta, had been asked by this court in the morning as to whether the regularization of the petitioner had been made personal to their post. Regularization of the service of the petitioners had been made personal to their post, comma, to which he had replied in the affirmative. Full stop. In the pleading, no, full stop. However, as he is not present today, comma, this court, comma, on going through the pleadings, finds that the regularization don't say how, but then just say However, the petitioners have not annexed the order regularizing their service their, as a master roll work. No, have not annexed any order showing regularization of their service. Wait, it's here. That's fine. That's fine. Right. The office memorandum number EC bracket one slash four, no, EC bracket 1452 slash 99 dated 28 Feb 99. Issued by the secretary to the government of the finance department. Bracket page 73. And the office order number 130 of 2003-4 issued by the executive engineer bracket PHE, Silchar division number Roman 2, Silchar, shows that the regularization of master roll workers has been done against posts made personal to them, and that the post would be abolished with the cessation, CESSA, cessation of their services. That is that office order number 130 is at page bracket page 81. I think, madam, this is quite clear from me. No, next one. The petitioners hearing pray that that they may be promoted to a great people. Next one. Miss Huh?
Kalita. M.
A-
Kalita.
M. Kalita, learned counsel for the PhD department, submit that in terms of the division bench judgment of this court, past it, Dilip Talukdar and others versus State of Assam and others, reported in 2017, 2 GLP 135. Comma. The petitioners cannot be promoted to a grade 3 post as the posts held by the petitioners are ex-cadre posts. They submit that the fact situation in the above case of Dilip Talukdar and others, Supra, is similar to the fact situation in this case. in Dilip Talukdar Super. This court has, the division bench of this court has held that promotion to a higher rank can be considered only from the feeder cadre and not from an ex cadre. As the petitioners in Dilip Talukdar Super had been, who are work charge / master role workers whose services had been regularized against posts made personal to them. They were ex-cadre posts, they were holding ex-cadre posts and accordingly could not be promoted to grade C cadre. As such, the writ petition, which had been dismissed by the learned single judge, was affirmed by the division bench in Dilip Talukdar. In the case before me, I also find that the petitioners who are master role workers have had their services regularized against posts made personal to them. In view of the judgment of the division bench of this court in Dilip Talukdar, the petitioners who are holding ex-cadre posts cannot be promoted to grade C cadre. According the writ petition is dismissed.
Thank you.
No, accordingly, there being no merit in the writ petition, the writ petition.
May please vote. But the matter pertains to denial of promotion on the basis of adverse remark. This is the second round of litigation, my lord. Earlier, your lordship is directed to communicate the adverse remark and it was disposed of in tune of Devdutt's case, my lord. Thereafter, it was communicated and thereafter, my lord, adverse remark, the adverse remark which was communicated, it was baseless and we are challenging that. Lordship.
Adverse remark is baseless.
Yes, my lord. And thereafter, a contempt case was initiated, my lord, against them. And in that contempt case, your lordship will get the order on,
Contempt case was initiated. Why?
because as your lordship has directed,
The direction was not.
direction
was not
direction
complied
was
with.
not fulfilled. That's why contempt case was initiated.
So now
Yeah.
your representation has been dismissed, has
Yes.
been rejected,
They have kept my adverse remark unchanged, my lord,
unchanged.
unchanged.
So what is wrong?
My lord, basically the wrong is that, my lord, the basis of the adverse remark, if your lordship, I will look at the adverse remark, my lord, first,
No, Mr. Counsel, what is the law on this aspect?
my lord.
What is the law
There-
on this aspect?
My lord,
Can,
in this,
you see, we are not, we are a court.
yes, my lord,
The,
There is a limited-
the officers who write the ACR know more about you
my lord,
than us.
my lord.
We have got no clue. Now, do you mean to say that the court should substitute the views made by the officer who see him every day?
My lord, though there is a limited scope of judicial scrutiny in this regard, my lord,
Where is the limited scope?
my
I
lord,
don't see any scope.
but under 226, lordship can exercise the jurisdiction. If there is any mere illegalities, prima facie, if there is any illegalities, my lord,
Not,
if your lordship has,
no.
my lord, kindly have a look at the adverse remark, my lord, at page 159.
Why show me what is there?
My lord,
What is there?
my lord,
Show me the law. You see, the reason the Supreme Court had passed Devdutt was so that a chance could be given to the concerned officer
my lord, in
to make a representation against the grading given.
My lord, in another matter, also Supreme Court has clearly said that if there is any arbitrariness in putting the adverse remark, then lordship can exercise the jurisdiction under 226.
Very difficult, but where is the arbitrariness? How do we know? We don't even know the officer.
My
The
lord,
office, huh?
that's why I'm stressing on that point here. Kindly have a look at the adverse remark, my lord. Kindly have a look.
Okay. Page?
Page 158, my lord.
Yes.
My lord, got it. My lord, at the part one, my lord, name, Sri Hemen Mohanto, father's name, so and so, date of birth, so and so, educational qualification, BSc, designation UTA, industry section, Dibrugarh district office. For special qualification, so on. Particular kind of class of work on which the individual was employed during the period of report. Perform as district officer and overall in charge, looks after KGP, KPC, and attended all meetings with district administration. All meetings with all district administration. Conduct good regularity, punctuality and attendance regular, generally in intelligence, average, trustworthiness, trusty, active, performance of duties, average, knowledge of branch, department, so and so, average, knowledge of rules, regulation, average, capacity, noting, drafting, average, ability to supervise, average, whether fit for confirmation to earning higher responsibility, fit. So, my lord, regularity and punctuality in attendance at point number 3 is regular. And in part 3, my lord, what is the remark, my lord? One of the liar officer of KVIB, means Khadi Village and Industries Board, he used to leave headquarters without permission very often, which questions his integrity and devotion to duty. That is the only remark, my lord. And how they have put this remark, my lord. First thing, there was no so-called whether I was absent. There was no disciplinary proceeding whether I was absent, my lord. There was no even complaint from the district administration that I was complained during that, I was absent during that period, my lord. And nothing was done. And merely putting this remark, they cannot justify it, my lord. That is my humble request.
One of the liar officer, yeah. He knows you personally, what to do?
My lord,
He knows you personally.
no,
That's
it
why he
cannot
said
be,
it.
my lord.
Otherwise, if he doesn't know you personally, he wouldn't have said this.
Because why, my lord? I was working in another district, my lord, under the supervision of that of the district head, my lord. That is the DC, my lord. The DC has to complain about me because the person who is putting the adverse remark is sitting in the Guwahati headquarters, my lord.
No, not
My lord,
necessarily.
how he can know my that I was absent? I was.
No, you see,
Yes, I was without permission. I was leaving the headquarters, my lord.
you see, I am the portfolio judge for some district. I know the ACR of I know the characters of some of the judges for whom I write the.
My lord, someone has to inform your lordship. Then
No,
your
no,
lordship will
I-
know that.
No, I can personally know that also. When they have seen you, it's not that they are somewhere in Mars and you're somewhere in Venus or something like that. Nothing like that.
My lord,
There is nothing that. I
And-
mean, it's not impossible to not
and one
know a
more-
person.
one more aspect, my lord. The higher authority who was supposed to review my representation, they have not mentioned who were the higher authority, my lord. They have simply stated in their letter that it was by the board of directors. But there was no mention that who was the higher authority, my lord.
Board of directors have done it. So what is the,
No, my lord, it cannot be done.
who should it be? Who should be done by whom? According to you?
This should be the handloom and textile department, my lord. This is the higher authority, my lord.
I got categorically said that it has to be done by the board by.
It is a board. You are working for the board.
No,
Board by.
who were the higher?
Who is the accepting authority?
My lord,
Who is the accepting authority?
Here the accepting authority is the CEO, my lord, Chief Executive Officer.
And board is higher than him. Difficult.
My lord. My lord, may issue notice, they will come with reply, my lord.
You show me the law. How can we change?
If your lordship give me one more chance, then I will definitely place the law, my lord.
I will place it. I'll give it to you.
No, I will place the law, my
No,
lord.
no, I will give it. You see, the Supreme Court has passed many judgments that the courts cannot substitute their views over the views made by these authorities, especially with regard to ACR.
My lord,
What?
fix it on the next day, my lord. I will satisfy your lordship.
No, no. Supreme Court is there. How can you satisfy when Supreme Court has
My
satisfied?
lord, I will place Supreme Court judgment itself, my lord.
You are supposed to bring it today.
My lord, I will place it. My lord may give a chance at least next week, my lord. I will satisfy your lordship.
One of lawyer officer of KBI. He had to leave headquarters without permission. He used to leave headquarters very often. Right. Yes, any judgments? Offhand, no. Both of you have fun. You have come for the first time. Yes, you have to come prepared. You cannot say, today I'll come, I will read half a paragraph. Then on the next time I'll read the second paragraph, third time I'll bring judgments.
My lord, I am humbly requesting your lordship that one more chance, my lord, I'll satisfy your lordship. Kindly fix it on the next week, my lord. I will place the Supreme Court judgment.
You bring it at 2. I'll wait for you.
My lord, in the next week, my lord.
2 o'clock.
My lord, can it be on the next week, my lord?
2.
My lord, it would be difficult, my lord.
There is HCC online.
My lord,
You
I
have
know,
got your GLP,
but it would be very
DLR.
difficult. Monday, my lord.
You got your phone.
My lord, Monday.
Instead of watching YouTube
Can it be on
or
Monday, my
Facebook, you do that.
It's humble request, my lord. Can it be on Monday? My lord, on Monday, my lord. Humble request.
How can you substitute the views? How can this court substitute the views? I do not know whether you eat toast or omelette for breakfast. They know.
I'm assuring your lordship that I will satisfy your lordship on Monday, my lord.
I don't think. So if you cannot come, then I'll pass out.
My lord,
2 o'clock, 2 o'clock.
my lord.
The Lordship, they have filed this IA for the question of the interim order. I would like to file a reply to the IA.
Huh?
I'd like to file a reply to the IA. for the
We have
petition.
filed the second
So let him fight. What?
After 2002, the time order was passed in 2022, lordship as well.
Oh, 2020. What is this matter about?
Lordship, the memorandum of charge was issued to the petitioner lordship on the charge of misconduct of his
Just
behavior.
show me the fight.
And it has already been decided. Otherwise, your Lordship, the doctrine of constructive certificate applies.
The
And I'd like to give a detailed reply to this whole.
proceeding is
I-
still in the initial stage lordship.
Ah,
At this stage, the repetition is not maintainable. Even the repetition is not maintainable.
Your Lordship,
Memorandum of charge has been issued to you.
The lordship.
So
And he was
what is the
given the-
question? Where's the question of memorandum of charge being stated?
it is a good thing to revolve around one particular issue.
Huh?
The petitioner, he wanted to go on deputation to a particular organization, NHS. And he was refused the tenancy to go on deputation. Now, that to actually had that refusal order was not communicated to on time. And he approached the honorable court saying that now I want to go on deputation. And that refusal order it was not communicated to him on time. And then this honorable court, the learned judge, he allowed the restriction based on the participating judgment, saying that effective communication is required in order to make an order effective. That was not communicated, the refusal order. And against that order,
wherein he was allowed to go on deputation to the NHAI. The department approached the honorable division. The division bench dismissed the this appeal filed by the department. And I was directed to, and they were directed to issue the NOC, so I can go for deputation.
Okay.
The case is same set of facts, already decided set of facts, same set of, same allegation. That I did not obtain the permission and I appeared in the interview. And then I was selected on the basis of the interview. And that is the misconduct that is being alleged. That issue has already been decided by the honorable division bench as well as the honorable single bench in this matter. That is why I'm stressing on the doctrine of constructive rectification, because the issue is decided. And after that, after he goes for on deputation to the NHAI, they issue this memorandum of charges on the same set of facts. And those particular set of facts were actually after looking into identical set of facts, those were stayed. That memorandum of charges were stayed because of this application of the doctrine of constructive rectification.
But you
And
already-
then they filed this particular IA for vacation of this particular supreme order, saying that no, just because the memorandum charges has been issued, the honorable court cannot interfere at this stage. That is the whole issue. And I would like to bring on record that certain facts, certain communication, their own communication, which they have alleged in this particular IA, I would like to file a reply to them, a detailed reply.
but in the earlier set of decisions, it
So
was
this has come for the first time,
Yes,
madam.
but that-
lawsuit,
This has come for the first time.
lawsuit,
Can you file a reply?
not that many with the lawsuit.
Mr. D. Bora, learned counsel for the writ petitioner is granted. How much time?
2 weeks time. Now it's posted target.
2 weeks time. Are you file? Will you file within 2 weeks? Are you sure? Don't take time only for adjournment.
That is what, because Kargil right now,
Lawsuit,
taken here to come down to Srinagar for getting the authorized certificate. So that is the ticket.
So how much time do you want? 3 weeks time.
3 weeks time, you're not.
It's granted 3 weeks time to file a reply. to the application. Huh?
In the pleadings have been completed in the repetition itself lawsuit. And they are taking time since April lawsuit for filing reply. Till they
And,
have filed reply.
Mr.
Okay.
Okay, this is the matter. Give a date.
The pleading on behalf of referendum.
I mean, listed on 7 November.
Mr. C. Barwa
I'll file it.
appears for point number
I will see.
5 and 6 in the IA.
I have copies not up to me in the petition.
IA though you don't need.
Not it, but. the
No,
copy
wait. Just wait. No hurry.
Seven.
When's the reply?
Your lordship is listed immediately on after vacation, 7th or 9th November.
Vacation lawsuit.
Immediately after vacation. Because
Before vacation.
before vacation, motion
This is what it is. No time before. Because it will be motion day. But anyway, for filing the reply.
I'll file
filing.
the reply. Your
Just
lordship,
say, whatever.
by 17, 18, 19, I will file it. 19 October.
So we shall file the same on or before. On or before, 18.
18.
On or before 18th.
Very.
With copies being given to the council for the respondent. The councils for the other side. On or before 18th.
Your lordship is listed on 7th or 9th.
This is the matter on 21.
Immediately on
This is the matter on 7. 7/11.
Very.
Okay, then in the main writ petition, Mr. D. Bora is given last chance to file affidavit in reply. Which should be done on or before 18/10. 18/10/2026. Bring this matter on 7/11.
After interim order passed,
Interim order passed today shall continue to the day.
highly okay.
Mr. C. Barwa appears for point number 5 and 6. Yeah,
It's petition.
yeah, it's a repeat. Are you finding anything?
No, because by as per his information, from SHODS from deputy chief, he has come back. So
So are you finding anything? Nothing. So he submits that the response number 5 and 6. We will not be filing any effort.
The petitioner also is working in as a senior register in the divisional commissioner of Tapa division. Now also the petitioner has challenged the promotion order of private responder. Because
7 and 8.
now also the particular office has been abolished. So I want to implement general administration department and also the district commissioner general. The staff of the divisional commissioner has been marked with the district commissioner.
Any objection? Right, Mr. S.K. Das, the counsel for the applicant. Read petitioner. Read petitioner. Raise that. The opposite party number 7 and 8 may be included as response number 7 and 8. If they are repeating. Mr. A. Cooper and counsel appearing for the
EAD.
Huh?
EAD.
for the GAD. And Mr. R. Das. Appearing for point number 2, submit that they have got no objection to the application we have. In view of the submission made by the counsel for the party. The application is allowed. Petitioner shall submit. Petitioner shall submit a amended petition.
I can submit that for the second notification, I can submit a space prospect.
The petition shall, application submit, fresh prospect to the registry within 10 days.
Okay.
I accordingly. report.
Transportation also. It cannot. We have filed our affidavit.
No one
Yes.
appears. Huh? What do you want?
No, that's it. Just,
You find their affidavit?
No.
None appears for the petitioner also. R.X. Chauhan is here. It's R.X. Chauhan. It is noticed that none had appeared on the last court date also.
D. Sharma.
Huh?
D. Sharma. D. Sharma.
Who is Isha? It is noticed that none had appeared for on behalf of the petitioner on the last day.
Their prayer was that they have not, in the advertisement, there was no provision of 4% reservation for the presented. And it was made up. So it was
It was there.
it was there. That's how I have to-
Let us see the other
Page number 62, Lordship.
page number.
62. Sorry, Lordship. Page number. Point number 4, Lordship.
Page. Page.
Lordship. Page 3, Lordship. Of our affidavit. There may be a mistake in the president.
Huh?
There may be an
Page three, you said,
Page 3, Lordship. Point number 4, Lordship, the last part of point 4,
page three of affidavit of this point number 3,
Lordship.
page 3. Yes,
That, further in the state advertisement, it was also mentioned that the present number of posts as mentioned above are tentative and final position of vacancies and reservation of posts shall be published in the due course of time and before final selection. It was there in the advertisement and subsequently all reservation including posts reserved for QBT candidates in the official website of Board of Secondary Education. And that is so and so notice dated 23/8/22 in widely published new reading newspaper and vernacular dailies of Assam on 24/8/22. It was published. Annexure 1 and 2.
let us see the advertisement.
And
Okay, it was in the it was uploaded separately. Is it?
Lordship. In the advertisement in annexure 1 of my affidavit. Lordship.
Yes, where? Okay.
In the second paragraph, it's just in the first part, Lordship, the
Yeah.
second paragraph. There will be reservation of posts for various categories as per prevailing government rules. The detail of
Okay,
vacancies,
okay.
including particulars of pay in will be
Okay. But where is the reservation?
the reservation is annexure 2, Lordship.
Annexure two.
This
No, this
detailed
annexure one.
vacancies.
Where is annexure two? Okay, annexure two.
The detailed vacancies of
Yes,
class-
where is the PWD?
the blindness and low vision, these the number of posts 5,
Five,
these and hard of hearing
yes,
4, like this.
autism. Okay,
Post is a 13.
that's right. The petitioners have challenged the advertisement issued by the respondents number 3 and 4 on 25/3/20. But there are two advertisements.
That's it.
Madam, there are two advertisements. On 25/3/22, advertising a number of grade 3 and grade 4 posts to be filled. According to the petitioners, no posts have been reserved for persons with disability. As required under section 34 of the Rights of Persons with Disabilities Act, 2016. Wherein 4%, wherein there has to be 4% reservation of the total vacancy. No, not the para.
Hold on.
Para 4,
That's it.
no, the para 4 of the affidavit in the position filed on behalf of the respondent number 3. It's to the effect that detailed vacancy position showing reservation, including posts for the persons with disabilities were made. And in this regard, the respondent number 3 has also annexed the detailed vacancy. But this is only with regard to class 3. What about 4? Class 3, 4. What about 4?
That's that part is there, lordship.
Huh?
It is also equivalent, lordship.
No, class 3 post only. Class 4 post is not made. Grade 4 post is not made. Only with respect to class.
Yes, sir.
So what about it? And first of all, were made. Huh? First up. Next paragraph. As the one appears for the petitioner. For the petitioner. Come on. The matter is adjourned for 4 weeks in the interest of the
Yes, sir, lordship.
as part of last order, look at the name of take home, the petitioner is the.
In this matter, we have received the travel instruction and we are preparing that.
Here for whom?
Lordship, for the additional. For Mr.
For
K.
additional age is not a party, Mr. Council, he is representing a party. Which party?
Okay.
Who is for the private respondent?
My lord, I am appearing for the private response.
Are you filing your affidavit?
My lord, everything is a matter of records, my lord. The petitioner has been granted, his seniority has been restored in terms of order passed by the Assam Administrative Tribunal as well as by the Honorable Court. And his seniority has been restored, my lord. So against that, my lord, the petitioners have come, my lord. And the petitioners have been directly appointed in the post of SI, whereas the petitioner, the seniority of the private respondent in the post of Havaldar has been restored, my lord. So they do not have.
No, their case is that
Yes, my lord.
you have been made senior to the petitioner
Yes, my lord.
from a date prior to his promotion of.
Yes, my lord.
It's on the basis of, it's on the
He has
basis of.
been made senior because, my lord, originally in the year 1997, my lord, what happened, my lord, in the year 19.
No, on the basis of some order, you said.
Yes, my lord.
Where is the order? Is that under challenge here?
My lord, this honorable court has passed an order and my lord, the petitioner filed a representation before the respondent authorities. And when his representation was
Let
not
us see
considered.
the order.
Yes, my lord. Your lordship want to see the speaking order or
Any order, I want to see the court order by which, according to you, your seniority over the petitioner has been restored.
yes, my lord. My lord, page 96 to 100, my lord. Yes.
Yes,
Operative portion, it starts at page 97, my lord. Petitioner, paragraph 2, my lord, petitioner case relates to deprivation of seniority at
Just a minute. Your name is what? Tapan Kumar.
Tapan Kumar Mohanto, private respondent.
Private respondent.
Yes.
Okay.
Petitioner's case relates to deprivation of seniority at the time of his promotion from the post of constable to Havildar clerk, which was done on 17/11/97. Petitioner's grievance is that due to his seniority being counted from the date of joining the post of Havildar clerk, the petitioner lost his seniority to his juniors as he joined the promotional post on a later than his juniors. The issue was that, my lord, his junior was promoted and posted in the same battalion. He was promoted and posted in a battalion which is at a distance of about 200. So therefore, there was delay, my lord.
They're delay in joining the post.
Delay in joining. That's why he lost his seniority. That was the issue. Petitioner's case is that he was promoted from the post of constable to Havildar clerk on 17/11/97. However, he was released as a constable from 13th AP Battalion, Lakhipur, only on 30/11/97. Which enabled him to join his promotional post of Havildar clerk in the 14th AP Battalion, Nalbari, only on 5/12/97. That's why delay was there. On the other hand, the other constables who were junior to the petitioner in the grade of constable joined their promotional post earlier than the petitioner, which included the respondent number 5. According, the petitioner lost out his seniority due to the delay in joining his promotional post. The petitioner was thereafter promoted from Havildar clerk to ASI on 19/10/2001 and to the post of SI on 23/2/2011. He thereafter filed an appeal representation dated 27/6/2016 before the state respondent, requesting them to restore his seniority that he had while he was a constable. As respondents did not consider the petitioner's appeal representation dated 20, he filed a case in Assam Administrative Tribunal, Guwahati, which was registered as case number 20. The Assam Administrative Tribunal, Guwahati, is disposed of case number 20 by order dated 13/12/2016 by directing the state government to dispose of the petitioner's appeal representation. As no action was being undertaken in pursuance to the order passed by the Assam Administrative Tribunal, the petitioner filed the present case on 13/6/2017. On 31/7/2017, the Inspector General of Police, Assam, passed a speaking order in compliance of the order dated 13/12/2016 passed by the Assam Administrative Tribunal, Guwahati, in case number 20. Wherein it was stated that the interstate seniority of the petitioner was fixed as per his position in the promotion order of Havildar clerk issued by memo number 20 dated 17/11/97, and he was placed above ABSI Akshay Ali. Means, my lord, he was initially he was senior to Akshay Ali. So his seniority position was restored only, my lord. On the same date, that is on 31/7/2017, another order was issued by the Inspector General of Police, Assam, stating that the petitioner was given interstate seniority as per his position in the promotion order of Havildar clerk issued on 17/11/97, and that he was placed above ABSI Akshay Ali. Petitioner's counsel submits that ABSI Akshay Ali was the petitioner's immediate junior in the grade of constable and also in promotion order of Havildar clerk dated 20. He submits that said ABSI Akshay Ali was promoted to the post of SI on 9/10/2009 and inspector on 16/11/2016, much prior to the petitioner. On the other hand, the petitioner was promoted to the post of ASI on 19/10/2001, SI armed brass on 23/10/2011, and inspector on 22/11/2021. Petitioner's counsel submitted on 4/2/2022, the petitioner submitted a representation to the Director General of Police, Assam, to consider passing an order to refix the date of interstate seniority of the petitioner in the rank of SI, with effect from 9/10/2009, and in the rank of inspector with effect from 16/11/2016. That is the date when Akshay Ali was given promotion to the state post. However, the respondents have not considered the petitioner representation dated 4/2/2022 till date. Learned counsel for the petitioner submits that the petitioner may be allowed to submit a press representation to the Director General of Police, Assam, for reconsideration of his seniority in the various grades of ASI, SI, and inspector on the basis of his seniority position mentioned in the speaking order and the order dated 20, both issued by the Inspector General of Police, Assam. MS MD for a learned junior government advocate, Assam, who appears for the reference number 1 to 4, submits that he has got no objection if the prayer made by the petitioner's counsel is granted. On perusal of the various orders passed by this court finds that no notice has been issued upon the respondent number 5 till date. Considering the submissions made by the learned counsel for the parties and keeping in view the facts and circumstances of the case, this court is of the opinion that the petitioner should be given liberty to file a fresh representation to the Director General of Police, Assam, highlighting his grievances. However, keeping in view the fact that no notice has been issued to the respondent number 5. In the instant case, this court is of the opinion, further opinion that the concerned authorities should dispose of the petitioner's representation to be filed by him only after an
And
opportunity.
then where is the speaking order?
Speaking order is at page, my lord, 101. 101, annexed 6, my lord. Here is the representation of Inspector Tapan Kumar Monto of Commando Battalion Mandakata, North Guwahati, seeking
Okay,
restoration.
so they are challenging this order 101.
Not only this one, my lord, because they are saying that the order passed by this honorable court is
No,
also.
but this, the court, the order passed by this court,
Yes, my lord.
it has not decided the issue.
Yes, my lord. Yes, my lord.
So we'll have to decide the issue.
My lord, but his seniority position.
Correct,
the
correct.
post
No, no,
of
no.
builder was.
Are you ready to argue? He's not ready to argue. That's the
Like,
point.
my lord, my predicament is that, my lord, that Akhir Ali, my lord. Recently, he has been, although new gradation list has been prepared and I have been
Yeah.
placed above Akhir Ali. Akhir Ali doesn't have any grievance, my lord. He has not filed any complaint. Now, my lord, a new now further promotion has been made to the post of junior grade APS, my lord. Wherein, my lord, my case has been kept in abeyance due to the interim order passed by the honorable.
Oh, there is an interim order passed.
Yes, my lord. Because the petitioner is fighting for last several years, my lord. No,
Oh, on the last order, there is a, on the last order, there is a, yes, I see.
yes, my lord.
But when this order, this case was placed earlier, there was no interim order. Now it is there, I see.
Yes, my lord. Because, my lord, the issue is, my lord, the
Yes, but
Kindly pass over the matter for time being. Here you don't take the answer.
oh,
yes, sir. Because seniority position in the
And
post
the
of 9th. Yes. Oblige, my lord.
Highly. Yes, yes, Lordship, I may be up to some days, Lord. I have not filed a appeal because this is all illegal appointment.
so what do you want? What do you want?
1 week time, Lord, 2 weeks time
For what?
to file a appeal.
Okay, Mr.
P. Sharma.
B. Sharma.
P. Sharma.
P. Sharma, that council appearing for
Appeal.
the response number 3 and 4.
Yes.
Is granted 2 weeks time to file affidavit in the police station. This is the matter.
I'm staying for my big kid.
22 matter.
We're out of service, but
Okay, 22 matter. He says that you are what illegal appointment.
Yes, Lord. That's
well, in my case, there was a situation. Some cases,
illegal, no advertisement. No advertisement.
there are
CID case is also pending.
There
The
are
fact
three-
is that we are about to procure a copy. All our things in Lord. All documents are.
We'll see.
obliged.
Academic side, yes.
For
For
what?
For filing.
For filing
Affidavit.
affidavit in opposition. Okay. Mr. S. Data, land council for the respondent number 123.
Yes, sir.
You granted a week's time to file affidavit in opposition. This is the matter.
The date may be taken.
What is the date?
22 minutes.
Is the respondent supposed to file an affidavit matter?
What is the matter about?
Well, it's matter relating to my lord appointment on sub-petitioner ground, my lord. If a lordship turns to my lord, case 37 for a one.
Seven.
37, my lord. Well, they
applied for appointment on compassionate ground, my lord. And in the animal husbandry department, my lord, there was no post, my lord. So, my lord, first part, my lord, the remaining 11 numbers of eligible candidates proposed for grade 4 post, along with the remaining theatre candidates proposed for the grade student for my lord candidate shown therein below could not be accommodated due to non-availability of sufficient vacancy. Therefore, proposal shall be forwarded to other departments. This is the minor dated 31 3 my lord, 39/2020. Thereafter, my lord, if a lordship sees my lord page 39, my lord, there was an advertisement, my lord. 39. Page 39, my lord. Yes, there was an advertisement, my lord. 13,300 are vacant posts are there. Great format. They are supposed to give a reply to that effect, madam. Whether our cases are considered, madam. What to do? His case is that his prayer for compassionate appointment has been rejected on the ground that there are no vacancies. However, advertisement has been issued in March 22 to the effect that 13,000 vacancies are to be filled. So what have you got to say to that? The concerned administrative department will where he has applied, they will have to respond. Correct. Otherwise. Out of these, you see now. But then, his other, now the problem is. What about clause 15 of 1/6/2015? Other department?
Any other department. But so far as these things of immediate necessities,
Ah.
these actually for immediate necessities.
Correct,
Lordship.
correct,
This
correct.
is not that for 2006 or
Correct, it is not, it
2000.
cannot be another
They have
form of.
applied and their
Ah.
case has to be considered on the view of
Correct.
this lordship.
No,
This cannot be
no,
lordship.
page 37, can you,
Whatever it is.
page 37, you see, there is a direction. Whether it is-
Direction is their
Now-
lordship, but
now-
interpretation has to be their
What are
lordship.
you going to do? Are you going to file an affidavit or what?
Lordship has to segregate the cases, lordship.
That is not affidavit. No, but then there is some merit in what they say. Unless you segregate the cases, how are you going to decide? I don't think the death was in the same year. No, my lord, page 37, it clearly says, my lord. My lord, due to non-able.
Regarding segregation.
The question is, my lord, when did some of the government servants die? Some might have died in 2010, some might have died in 2019. So so each case will have to be decided individually. That's what they say. Fine. It is not a form of recruitment. It is only only with regard to mitigating the hardship. And there are also immediate hardship. Immediate. That's that I am. Right? Or I can from the same department. That 13,000 will come. But then if it's, is it from a particular year or different year? Okay, I know. They'll have to see, you see, because
Someone messaged my
when did they die? When did some of them die? I have filed individually every case.
very individual.
Individually filed.
Hard, hard activity.
I don't know. I leave it all up to you. What you have to Are you going to file any affidavit or what? Or is it going
Lordship
to-
will file affidavit, Lordship. Kindly give us opportunity, 4 weeks time, Lordship. Because these are of new cases, Lord. 4 weeks time, get granted, Lordship.
There's an order of this court pilot on 3/5 pilot.
Actually, what affidavit will you file on?
Regarding the claim that kind of 30,000 vacancies were there. So how- Why they? Probably they are trying to become.
Actually,
That of course, the
And veterinary also, department also needs to be, they also need to verify.
yes, so who are the council?
As for the kids, the concept of here, the couple of kids are at the
M. Kataki is council for which department?
secondary department.
Can you come?
You will adjourn the matter.
If they taking, get me an order, whether it's a, that's the complete of the legal. Otherwise,
That is the,
That is also the case.
that is the only thing that can be done.
Yes, yes. But let them on record file something, my lord.
No, what is to be filed?
What they have done regarding 13,300 votes, my lord. Whether amongst them, my lord, that 5% compensatory down has been considered or not.
You will not get a affidavit in that account. You'll have to, because this is spread out over a number of offices. And to carry out that exercise of 5% also might be a problem. Because sanction post and man in position post. Man in position might be, will be different.
That is true, my lord.
And cadets for the 5%, Lord.
So far, my lord, this court's order, my lord, 3/5/23, my lord. Mr. Or, my lord, the learned government advocate, he paid some time, my lord. Get inspected.
Lordship is okay, Lordship. We are not on that, but
Let's
when the
find
departmental council is there, Lordship,
Okay, right.
so they can better verify it. Lordship. They better-
On the part of the parties, this is the matter of the COVID. In the meantime, the council for the parties can obtain instructions and file affidavits in this.
Deeply obliged.
Well, up to 40, my lord.
Yes.
Yes.
May I please? Lordship, in this case, lord, petition was dismissed, subject to government proceeding. Thereafter, we have petition approved, petition approved, and that was disposed of the director to file them. And when appeal was not filed, my lord, in fact, appeal was filed on behalf of the petitioner from, since he was mentally not fit, therefore appeal was filed.
File late.
Lost. And
There is some
delay, my lord, and thereafter contempt petition was filed, and this honorable court granted liberty to file proper statutory appeal. Accordingly, that appeal was filed on the 20th January of 2021. And since then, my lord, that has been pending
20th January
2021.
2020.
20. Possible file it,
Let us see the High Court order.
lordship at
Page
page
26.
26. It is the order dated 7/1/2021, sir. But the operative portion is at page 27, sir. Last paragraph, sir. Considering the facts and circumstances of the case is in its entirety and in order to avoid any prejudice being suffered by the petitioner, he is granted 15 days time from today to prepare the appeal. And accordingly, what will find at page 28, that is the statutory appeal filed on 28 January of 2021, sir. That has not been disposed of.
Okay. No, but this court had directed that the appeal should be disposed.
Lord,
Then why did you file the contempt?
Lordship, that contempt was filed, appeal was filed, but that appeal was filed. Lordship will kindly peruse the order at page 25.
Yes.
That Lordship will, yeah,
Uh,
Lordship, that is the order. Lordship will peruse paragraph 1 to 3. That whereas the matter was referred to judicial department view, it has been informed by the judicial department that a letter dated so and so as referred to and rely upon the delinquent is in fact, no appeal. Hence, the delinquent, if the delinquent file an appeal, the department may condone the delay and dispose of such appeal on merit. However, if no appeal filed by the delinquent, the department may pass an appropriate order in compliance. with-
okay, so actually, according to them, he filed a representation,
Lost,
not an appeal.
not that. And accordingly, his order was placed before the honorable court during pending consideration of contempt. And accordingly, in the contempt order, my lord,
So fresh appeal was
Lord,
allowed.
it was not done.
Page 25, my lord. The appeal was considered, but it was observed that, my lord, that is not a formal appeal.
And
Usually something was filed. So that liberty has now been given. my lord.
accordingly,
So now the appeal was filed when?
Lordship
On
20 January.
2021.
Lord.
Now what to do?
Either, well, if not disposed of. What will the right order to dispose it of?
Will dispose it of? Why keep
Lordship,
it?
with a time.
And if already disposed of, my lord, the whatever is the reason that is
Third, Mr.
M. on.
M. Mohan, learned counsel for the petition. Also heard Mr. P. Gogoi, the learned counsel for the PW. The petitioner has prayed for a direction to be issued to the
Respondent number 3, Lord.
respondent number 2
Lord.
to dispose of the petitioner's statutory appeal dated 20/01/2021. Challenging the order of dismissal of the petitioner dated 28/12/2020. 28/12/2012. 12.
Got
I got it.
Lordship, after dismissal order, because he approved the honorable court and that has been in a repetition. That petition has been pending till 2018.
Okay, right. Next.
Right.
The brief facts of the case is that the petitioner had been dismissed. The petitioner who was working as an LDA in the office of the executive engineer, PWD, Barpita Rural Roads Division was dismissed from service by order dated 28/12/2012. The petitioner challenged the same by WPC number 6632/2013. Next paragraph. WPC 6632/2013 was disposed of by order dated 30/10/2018 by directing the respondent number 2, who was the appellate authority to consider and dispose of the petitioner's appeal dated 7/1/2013, challenging his dismissal order. Next paragraph. As the order dated 30/10/2018 passed in WPC 6632/2013 was not being complied with, the petitioner filed contempt case C 652/2019. During the pendency of the contempt case, the respondent number 2 issued the order dated 6/12/2019, wherein it stated that wherein it was stated that the appeal filed by the petitioner was in fact not an appeal. Was not a formal appeal, was not a formal appeal. However, if the petitioner filed a formal appeal, the department may consider the appeal. In view of the above facts, the contempt case was closed by order dated 7/1/2021. By granting leave to the petitioner to prefer a statutory appeal in accordance with law. The petitioner thereafter submitted an appeal in terms of the order dated 6/12/2019 passed by the respondent number 2 and the order dated 7/1/2021 passed in contempt case C 652/2019. So the appeal was filed on 20/01/2021. The grievance of the petitioner is that the same has not been disposed of by the appellate authority till date. He submits that the present date petition can be disposed of if a direction is issued to the respondent number 2. So-
Here, when the order was issued, that penalty order was issued by the AGD. The next higher authority will be the CBD. In fact, the respondent was already delegated it to the respondent fee.
But he has given it to the respondent number.
So he has already delegated.
Acha.
Possible say, my lord, any competent officer.
Can be disposed of if the appellate authority disposes of the petitioner's appeal dated 20/01/2021 within a specified time. So Mr. B. Gogoi, the learned counsel appearing for the PWD, submits that he has got no objection to the same. Next para. In view of the submissions made by, in view of the consent of the parties, this writ petition is disposed of with a direction to the respondent, with a direction to the appellate authority
Yes.
to dispose of. Who is the appellate authority? There is-
Appellate authority is the commissioner secretary, but here perhaps they, appellate authority delegated some power to the respondent of court.
So he will say the appellate authority.
the appellate authority to dispose of the petitioner's representation within
Appeal matter.
appeal dated 20/01/2021 within a period of 1 month from the date of
50 days.
1 month from the date of receipt of a certified copy of the top. The writ petition is accordingly disposed of. There'll be Durga Puja of
Lordship. I live.
everyone will have to have at least mark 40 tons are coming from Bangladesh. They have allowed 40 tons, 40 days, not 40 tons, 40 days. Earlier 30 days. So you'll get more early.
Hello.
এই মৃগাঙ্গ দিলে চিন্তাটা ওলাই দি দিতে তবে মই দেৰি কৰি দেখি আজি যা কালি দিন
And I have that. 2023, my lord.
Just type it out, just print it out.
2023 SCC online RAJ 1288. Jagdish Prasad.
RLJ,
RAJ 1288.
want to just print it out.
It's Jagdish Prasad versus State of Rajasthan. Jagdish Prasad versus State of Rajasthan, my lord. If there is any vitiated by extraneous consideration, then High Court, the opinion is that, may I read, my lord? The opinion, the analysis and the decision, the court opined that while exercising power of judicial review,
though the court could not moderate the appraisal and grading of an employee, but if it found that adverse entries made in the SCR or grading given to an employee were vitiated by extraneous consideration, the court must interfere and quash them.
Where is the extraneous?
Lord, there is extraneous, and one more judgment, my lord, I want to rely it. If lordships give some more time, I will find more judgments, my lord, because I have found someone that, my lord. Wherein in one judgment, my lord, Supreme Court in 2009, 17 SCC.
Yes, you have looked for any judgments during the lunchtime? No, you quietly ate your lunch.
My lord,
Okay.
Huh?
What is my lord, effect? They have to go through a proper channel. And that has been created, the presentation has been made by him. Now, my lord, if there are, there can be review applications filed against that also.
Huh?
For expansion of the ACR adverse remark in the ACR manner. The employee has to go through a proper channel. He had filed the representation before the higher authority manner. That remained unchanged. Now that can be reviewed.
Who said that? Who said that? Who said that? It can be reviewed. From where are you getting this?
I was going to something.
Have you read Devdas judgment? Then what does Devdas say?
No, my lord, review not by the not under 226. By the authority.
You cannot make up. You cannot make up as you go along.
Our Devdas says that is not been communicated to the employee, my lord. That has to be, he has to be.
You see, there has to be a finality to things. You cannot keep on filing beyond what the Supreme Court says. You cannot go beyond that.
my lord, one more humble submission, my lord. His SCR was all time favorable. It has been admitted, my lord. If your lordship have a look at page 71, my lord.
Anyway, since you have tried to look for some judgment, we'll adjourn them.
Fine.
But and because they have not tried to attempt to find the judgment, there is a judgment of the Supreme Court against you.
I'll try to find out that.
Anyway, right, because I have not read the Rajasthan High Court judgment, and since you have tried to do justice to your case, we'll give you some more time to do some more research.
Highly objective.
Heard, Mr.
PM Deka.
BM Deka, learned counsel for the petition, who submits that this court, in its order passed in WPC 4067/2020, had directed the respondents to communicate the adverse remarks made to in the petitioner's ACR in terms of the decision of the Supreme Court in the case of Devdutt, Union of India Devdutt versus Union of India and others, reported in 2008, 8 SCC 725. The respondents thereafter communicated the uncommunicated adverse remarks to the petitioner. With regard to the ACR year 2018-19. And thereafter, an authority higher than the authority who gave the adverse remark decided the representation made by the petitioner against the uncommunicated adverse.
The representation of the petitioner was not accepted. Next paragraph. The petitioner has now made a challenge to the adverse remark that has been put in his ACR by the accepting authority. Issue notice. Returnable in 4 weeks, Mr. PK Munir, accept notice on behalf of phone number
3 and 6.
3 and 6, while Mr. Ardhar accept notice on their phone number 1. Ms. M. Banerjee, Bhattacharjee accept notice on their phone number 1. 4 and 5. 4 and 5. The issue herein is with regard to whether this court can substitute its views vis-a-vis the views made by the accepting authority. With regard to gradings made in, with regard to the adverse remarks made in the ACR. I'll list the matter of the court. Highly obliged. Acha, one thing you just find. The petitioner's counsel has relied upon the judgment of the Rajasthan High Court in Jagdish Prasad versus State of Rajasthan, 2023 SCC online RLJ 1288. Yes, what is this?
May it please the Lordship, the petitioners herein are direct recruits for the post of sub-inspector in 2010. And thereby they were promoted in the year 2016-17 again. Whereas the the private respondent here, at the time of his promotion, he was assistant clerk. My lord, this is actually a second round of litigation. Now, with regard to this effect, is because, my lord, there was an order of this honorable court itself, my lord's order. My lord's order is in page 97, my lord. And the effective part is at page 99.
Yeah.
That considering the submission made by the learned counsel of the parties and keeping in the view and the fact of circumstance of the case, the court is of the opinion the petitioner should be given the liberty to file representation to the Director General of Police, highlighting his grievance. However, keeping in the view the fact that no notice has been issued to respondent number 5 in the instant case, this court is of further opinion the concerned authority should dispose of the petitioner's representation filed by him only after given opportunity of hearing given to the respondent number 5. My lord, in view of the reasons stated, the petition is also given to file a special representation to respondent number 2. My lord, this order was of 24/5/2023. And my lord, at Annexure 6, at page, there was an order with regard to this that was 21/5/2023. My lord, we are not the respondent number 5 here. We are the petitioners, different petitioners who were direct requests. And he has been promoted from Havaldar to ASI, then to sub-inspector. And my lord, in fact, even giving in this order, there was.
You were direct recruits when?
My lord, in 2010.
Direct recruits in 2010.
10, my lord.
And he was a promotee
Yes, my lord.
in the year.
My lord, as per the, my lord, he was a promotee in the year 2016. So
No, you were promoted, you were direct recruit as what?
2000 at sub-inspector
As
2010.
SI
And I was
in
promoted to the-
2010.
Yes,
And his juniors were promoted as SI when?
In the year,
2009.
yes, my lord,
my lord, that is where,
2009.
Now, so you see, it's like this.
my lord.
If you are aggrieved with his seniority, you'll also have to be aggrieved with the seniority of his immediate junior.
No, my lord, that is what I'm trying to submit here, my lord. That has been recorded by giving wrong submission here, my lord. My lord, I'll just prove it to my lord. My lord may just see page 53 once.
Yes.
My lord, he had claimed seniority over Rajveer Singh. That is respondent number 5. In his repetition.
No, no.
Yes, my lord, may I just submit here, my lord? My lord may see Rajveer Singh
Just a
is,
minute, just a minute.
my lord may see page number 40.
Akhir Ali, actually.
Yes, my lord.
No, my lord.
Akhir Ali, not Rajveer.
My lord may just submit it. My lord may just see page 40. Page 40 of the report.
Yes,
My lord may see the respondent number 5, Rajveer Singh.
yes, Rajveer.
My lord. My lord, this is the first list when he was ASI constable. They were all being considered. My lord may see Rajveer Singh, 1504, my lord, at page 53. My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. At 10th number, my lord, Rajveer Singh. Rajveer Singh, my lord, 290.
No, page 53,
Page 53, man. Page 53. Page 53.
7, 8, 9. It's a 10, there's no name. There is no name.
My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 290, my lord. Rajveer Singh, my lord. Second,
11, Rajveer Singh is 11.
yes, my lord, Rajveer Singh. My lord may find it.
Yes.
Now, my lord may see the name of the petition respondent herein is at page 58.
Yes,
Tapan Mohanta, my lord.
upon Mount Avit. Okay, yes.
And Akhir Ali is down below. That is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14th, my lord. Akhir Ali.
In the same 58.
Yes, my lord. Same 58, my lord. Akhir Ali, my lord.
Number? Okay, at the 196.
196, my lord. Now, my lord, in his writ petition, my lord, he has given an annex, a typed copy. And this is as per the reading, my lord, that the following Havaldar clerk of different units are selected for the promotion of officer ASI clerk in the scale of pay and other allowances. Departmental proceedings are pending or contemplated against any one of them. They may be released promotion accordingly.
Where are you reading? Which
My
page?
page 60. Page 60. Type copy, my.
Yeah.
My lord, the second paragraph.
Yeah.
They may be released, promoted accordingly. Their interest and seniority will be counted along with the batchman in the rank of Havaldar's clerk for their promotion to the rank of AB, SI, GD in due course. That is the list that I read out, my lord. That his name was in the last. So, my
No,
lord,
his name was not, his name was at 164.
164. And whereas Rajveer Singh was way above him, my lord.
That's yes, surveyable.
Was way above him. My lord, thereafter, what happened? He filed an appeal before the Assam Administrative Tribunal. They gave a representation to be considered. My lord, he was promoted in 2017 by a retrospective promotion to be before Akhir Ali, just because Rajveer Singh was promoted, without holding any DPC, without looking at the fact of whether there was a vacancy available or nothing, and he was just giving a seniority, which has affected my seniority, and he has also never challenged his promotion to the ASI clerk or to the other promotions that has happened to Rajveer Singh in the year. And my lord, there is a settled Supreme Court judgment, even this High Court has reflected, that if a you are affected by promotion and you have to approach the court within 6 months, and he did not do it. And now, after I being a direct recruitee, the 37 of us to being a direct recruitee of 2010, got promoted in 2016, 17, and 18. At that time, he was never in the picture of the consideration that whether I should be promoted to sub-inspector or not. My lord, because I'm a direct recruitee, and I have a cadre, I have a strength of my own where I've been promoted. Now, if he has to go back to the position which he has left in, there has to be a vacancy that has to be there. Because, my lord, we are not affected by the Rajveer Singh. Because Rajveer Singh was senior, he got promoted, he got retired. That is different aspect. But he, while approaching this honorable court, he tried to show the fact that he is senior to Rajveer Singh in the list, and that's why he should be given an opportunity. My lord, no, my lord, that is his submission in the writ petition, my lord.
No.
I'll just read out his writ petition submission, my lord.
But Rajveer Singh is a party here, huh? That part. In the writ petition. he
Yes,
was a
also. And my lord, I'll just read his
My lord, page 44, paragraph 9. This admit,
Page 44, paragraph 9.
it may be stated, my lord, fourth line.
Yes.
That if the petitioner is provided his original due seniority over his juniors like that of the respondent number 5,
Like that, okay.
his promotion to the post of ABSI would have been given effect to 6/10/2009 instead of 23/2/11, and he would have been called for appearing in the said selection process for promotion to the post of inspector. It may be said respondent number 5, who is junior to him. My lord, is a statement, direct statement here. Has been called for appearing in the said selection process. In pursuance of the said selection process, the respondent number 4 has now issued a notification dated contained under so and so. So, my lord, he's a direct statement he has given in the court saying that he has been junior by producing a list where he has said, because in the second list, his name appeared in the second and Rajveer Singh's name appeared in the last. He has taken that opportunity and he has went and said in the court that he should have been given a seniority because he's junior, where Rajveer Singh is junior to him. My lord, and my lord, look, as per our condition, my lord, we are direct equity. We have been promoted to 17/18, and without holding any DPC, nothing, my lord, he has been given retrospective promotion.
Okay, this type copy at page 60 is wrong.
My lord,
Page 60,
yes, my lord.
this is wrong.
My lord, this
Chart.
is correct, my lord.
No, but then it says here, roster number.
Yes,
serial
my lord.
number.
My lord, may see the paragraph.
Page 60, 60.
Yes, yes, ma'am. Yes, my lord. They may be released, promoted accordingly. The interested seniority along with their batchmate in the rank of Havaldar clerk for their further promotion the rank of ABJ in due course. In this list, his name came second, but they have mentioned in the top that your seniority will be counted from your original list of Havaldar and clerk.
Originally, as per original.
Where is the reflection of
Akhir Ali, I claim my seniority above Akhir Ali, and that has been provided, ma'am.
Where is it provided? Nowhere they have given a statement. He has given a statement that he is.
No, no, my lord. My representation has been considered, they have examined the record and they have provided seniority over Akhir Ali only, not over Rajveer Singh matter. Because the original list of the Havildar clerk of 1997, Akhir Ali was
So
below me.
Akhir Ali was promoted when?
My lord,
2011.
as per the stand here in my lord, page 94, annexure 4.
Yes.
The sub-inspector Topon Kumar Mohanto, Police Commissionerate, so and so, who was promoted the rank of sub-inspector in 2011, is giving interstate seniority as per his position in the promotion order issued by memo dated so and so, and is placed above ABSI Akhir Ali. So, my lord, this is absolutely wrong, my lord, because this is without holding any DPC, without holding any committee, and without passing any reasoned order.
My it is not promotion, my lord. In fixing of seniority.
He said reviewing of seniority, even if a reviewing of seniority is should be there, my lord. At least I should be heard. The petitioner share should have been heard. We are the affected
My
party
lord,
at
the
large.
Seniority for restoration of seniority for which the respondent number 5 has claimed, my lord. That time he was not born, my lord. Because it is of the year 1997, my lord. And if your lordship peruses the recent gradation list, there all the date of joining, date of appointment as constable, date of appointment as ABSI, everything is there. Page 103.
So Akhir Ali was promoted as SI when?
SI, ABSI on 9/10/2009, my lord.
My lord, that is at 9/10/2009. That is at page 103.
Page 103.
No, you see, if Akhir Ali was promoted in 2009,
And ABI,
he is senior to you in SI. Because you were promoted in 2010,
No, my lord, I am a direct equity.
whatever it is. You see, the issue is, is there a seniority list of SI?
My lord, this is a seniority.
Where is that?
102.
Huh?
102. This was the inspector list. My lord.
102. That is, this 102 is for
Inspector,
inspector.
my lord. Yes.
Where is the seniority list of sub-inspector?
My lord, that has not been annexed.
You annex that.
My lord,
Let us see from there.
but here, my lord.
No, you see, one thing is that he was always senior to Akhir Ali.
My lord,
Is that a fact or not?
my lord, may I just submit here, my lord.
Yes.
he was senior, as per the list, he was senior to Akhir Ali. But my lord, Akhir Ali got promoted in 2009 itself.
Yeah.
With 2009 itself. Thereafter, there was a settled position. We got recruited into the direct recruitment happened. After direct recruitment, we got promoted. 30, we are the direct batch of promotees, we got promoted and everything. My lord, thereafter, he has now coming and claiming his seniority and trying to settle an unsettled position, my lord. Why would that? But after 12 years, my lord, after 12 years, the Honorable Supreme Court has clearly said, even this Honorable Court has, my lord, that if the seniority has to be within 6 months, he has not done so, my lord. And my lord, even if, my lord, that the seniority, there has to be a vacancy that's available, my lord. That vacancy has to be available, my lord. There has to be a position that has to
Or the supernumerary post can be stated also. sir.
No, vacancy was there.
Vacancy
Because,
was there.
when I approached the honorable court, by the interim order, my lord, your honor, the chief honorable court has been pleased to keep one seat vacant. Yes, ma'am. So interim order was there. Madam.
No, but your promotion was done by way, were you promoted with effect from 2009?
No, ma'am.
No.
This is-
Only seniority given.
Yes, madam, only seniority.
Only
given.
senior-
And I have been.
But- If seniority is given,
Yes.
but only in the post of constable.
Yes, ma'am. And
You,
subsequent.
so how, so you see, unless you are promoted to SI
Yes, ma'am.
with effect from the date Akhir Ali was given, how do you count the seniority?
That has been given, my lord. If your lordship Perugia page 103, my lord. 103, my lord. Serial number 35, Tapan Kumar Mohanty, reference number 5. And
Yeah.
36 is Akhir Ali.
Ah.
So, my lord.
This is seniority list.
Yes.
But where is the promotion order giving you retrospective promotion?
Uh,
Where is the promotion order
promotion order, my lord.
giving you retrospective promotion? There has to be a review DPC or something
Yes,
to promote you. Or can you be promoted without DPC?
no, without PTC cannot be promoted. Yes, madam. Because but there has to be a training has to undergo by the petitioner, my lord, the concerned employee, and thereafter only the promotion to the API can be made.
So where is that?
That
that is not there.
no, that will be there, my lord.
You see, there is, the court can no doubt set right or wrong that.
Yes, madam.
Only thing is that for you to have seniority is all right in a particular grade of a constable or whatever. But, or what, ASI or whatever.
Yes, ma'am.
But
My lord.
for, to become senior to him in the grade of SI, you have to be promoted from the date he was promoted, Akhir Ali was promoted.
Yes, madam.
Where is that?
My lord, the promotion order to the post of API. That
ABSI.
API. APSI, he was promoted in the year 2011.
Yeah, what is ABI? What is ABI?
API
Armed
means
branch
inspector,
inspector,
armed branch inspector, and APSI armed branch sub inspector. So the promotion order is here, my lord. That copy. No, no, it's there, 26. Oh.
Huh?
Date of effect of the, because when the interchange seniority
So where is the promotion order?
is the promotion order, you
No, no, as ABSI.
APSI. Okay, my lord.
Number 103. And 18 for mistaken.
Yeah.
You know, the serial number 35.
Yes.
Tapan Mohanty.
Huh?
Where the column 1. The ninth column.
Yes.
The date of it, promotion is here recorded as 9/10/2009.
The date of confirmation is not confirmed, ma'am.
No, that's a different thing. Confirmation is, where is the promotion order?
Promotion order of
You bring that will solve the entire case. That's all. That is the only,
the promotion order was initially of 2011, but after fixing the seniority, my lord, his case has been considered.
when you fix the seniority,
Yes, madam.
can you fix the seniority without being promoted in a subsequent cadre? Now supposing he's a SI.
Ah.
He's a SI. Can someone
Yes.
be given seniority in the cadre of SI without being promoted to SI?
No, madam.
Then
He has been
He
promoted.
has been promoted only in 2011. Where does it say his 2011 promotion is with retrospective effect from so and so date? Where is that?
That has not been, that there is no such order, man.
There is no such order.
Then how can you claim?
I think it is. The inspector. If he has done.
You obtain instructions. Where is the
My lord,
promotion?
if you lordship, Perugia, the impugn order, they have annexed 6 page 101 manual.
Yes, 101. Yes.
The interstate seniority in the rank of ABSI has already been restored. ADA by this order dated 31/7/2017. ABSI conveyed by memo number 20 and order dated 20 with effect.
So is this order under challenge? Page 101.
No,
Yes,
madam.
No, this is under challenge, my lord.
No, that is under challenge.
That is
but
under
that-
challenge,
that
madam.
ABSI
So it's under challenge.
That is under-
So you see, once it's under challenge, you have got to show that this restoration of seniority is based upon a promotion order effective from 2009. Otherwise, how can you show that Akhir Ali is junior to him? How can you show?
that order is.
So what to do?
What will be required?
Okay, you bring the record, show me the promotion order. Show me the promotion order of the petitioner, of the respondent number 5.
Yes.
Showing that he has been retrospectively promoted with effect from the date his junior was promoted. Okay, right. Third, Mr. K. Kumar, learned counsel for the state respondent.
And it being a required.
Additional AG appearing for the state respondents. Who submits that he will produce the reports to clarify the issue with regard to the promotion of the petitioner as ABSI with effect from the date his junior had been promoted.
My lord, the interim order passed earlier.
Interim order passed early. Interim order.
Hey, my lord, there is an order that till the next returnable date, respondents are directed not to take any coercive action before sitting the petitioner.
That is the problem because the Akhir Ali, my seniority has been fixed above Akhir Ali. Now Akhir Ali have been again promoted. And because of this order, I have been left outside.
Anyway, when can you bring?
2 weeks time.
Huh?
2 weeks time.
This is the matter. Give a date. October 10. 6. October 6.
My lord, this may be reflected.
Huh?
This may be reflected, my lord.
What?
That till the next returnable date, my lord. That is it.
This is the matter on 10th. The interim order to continue till the next day.
Much obliged, my
Your
lord.
lordship has heart rate there, so it may get the part has my.
No.
Your lordship has heart rate.
I don't want.
Your lordship, earlier.
If I every
Your
time I.
lordship is acquainted with the facts, my lord, now. Because that will, because otherwise, my lord, the junior person have again been promoted.
Then you see what will happen is again on the date, again you have to start from the beginning.
Yes, my lord, but then your lordship would be able to recollect, my lord. That's why, my lord, I pray for Parhat, my lord. It will, because otherwise the reference number 5 is again suffering, my lord.
Why? Other courts can do it. Okay, yeah.
Okay. My humble submission is that since your lordship has heard all the matter on land, so that's why, my lord, it may be kept as Parhat, my lord.
After is a Democles sort of.
My lord, then if it cannot be taken up on the next day, then it may be released from the Parhat, my lord.
No, if it comes, it comes. If I'm still here, it's there. Otherwise, no.
Much obliged.
Public.
Right.
Hmm.
Lordship was pleased to ask me whether the SLC has the right to
Yes,
Lordship, the judgment that has been relied on by the council lordship is put under challenge lordship and the BJP. So
that may be, but no order has been.
no stay order there.
Yes.
then no so at that lordship, the matter will be heard if there is any then.
Will be heard when after 10 years, then what happens? What will the petitioner do?
But even then the case has to be.
No, all such cases are disposed of in other cases, or other cases also.
I don't know if that is full of,
Why?
that is a different issue, I don't know.
Because this is my
Show me one case that has been
duty
disposed
on
of
my part
after this.
to
Okay, I
appraise your
understand.
lordship on this.
after
lordship.
this order. Huh?
It is my duty lordship to appraise your lordship.
No,
on
no,
this.
so I know of it. The only thing is that there's no stay order.
There is no.
So,
stay
so
order.
the,
Right.
so
lordship.
the, so
Because
the,
that's only
so the petitioner has to continue to eat also.
the part has been condoned lordship and the main police.
So madam, the world has to go round anyway.
Lord.
Then what to do?
That I'm admitting, that I'm not.
So
But
the
even
only,
though the lordship-
the question is whether DLC or SLC will consider.
That part already I have. It has been already considered by the agency. Regarding clause 50. In other cases,
Another case.
similar.
Yes, so this meeting minutes is there, madam, whereby SLC has considered. Only on that, no point waiting.
As your lordship, please. It's up to your lordship. Otherwise, lordship regarding it's a matter of 2011 lordship.
But that
Yes, lord.
was a 2011.
And this 2015 lordship, whether this will have the retrospective effect. This one is also their lordship. And clause 15 of the office memo of 2015.
No,
OM
you see, as per the, I think, as per NC Santosh,
lordship.
it will be, the OM will be as per the, as on the date of the consideration.
Sure.
When did the DLC consider?
It's considered long back lordship in 2000. It was prior to 2015 lordship DLC
Then-
considered.
Mr.
Prior to 2015 lordship.
In fact, there are, I think, at least
In
3, 4,
13.
huh?
It was in 13.
13, then 2015 is not applicable.
That
Your
what,
case goes,
There are ample many judgments on this
Because-
ground, lord.
no, Supreme Court has held in, I think, before judgment, that the OM that has to be considered would be the OM that is relevant at the time of death. But in NC Santosh, the 3 judges bench said that the OM that will be, have to be considered is the one that is applicable at the time the consideration was done. So if it was done in 2013, 2015 does not come into the picture,
that point,
then your case goes for a 6.
since that point arose in the single bench ballot when the bench of petitions were filed. In a similar
No,
case.
that is a different issue.
No,
That's a different issue.
There are two separate cases, man. In one case, after the 1/6/2015, and another set of cases were there, which were before the 1/6/15.
Correct.
And thereafter, when we approached to the honorable court, that since 1615 will not be applicable since the petitioner's father was expired prior to 15, and application was also submitted prior to 15. And that is why 1615 will not be applicable, so our case deserves to be considered. Then the NC Santosh case, it has been relied upon, and we have also relied upon some of the other judgment matters. But subsequently, the government relied upon saying that NC Santosh judges bench, where it is stated that prevailing scheme will be applicable.
Prevailing scheme at the time of consideration of the application.
But that part, my lord, we have been told that the thing, that prevailing scheme, that is, that means 1/6/2015 will be.
No, but then your case was decided in
Lordship,
two
this
thousand
case
thirty.
has not been
Yes,
discussed
but
yet. I
that-
have the
That
judgment.
point arose, my lord, in another set of.
No,
judgment.
no, that another
This
set
has not
was
been,
bothered about another
discussed
set.
here, Lord.
That is a
in this
different issue.
petition. Yeah,
Now
but not
here,
in this common judgment.
now in this case, NC Santosh judgment is clarifies the fact that this 2015
That
OM
point-
cannot be considered.
That point we raised, my. But ultimately, government said no, that cannot be.
Well, whether government says yes or no doesn't matter. If Supreme Court has laid down the law, we're going to follow the Supreme Court judgment.
No, that judgment somewhere refused, because the prevailing scheme means that as on today, whatever the scheme is continuing,
No,
that has been.
sorry. The above being said, the fact remains
Lordship.
that this court has already passed an order in 22
Lordship.
that it should be considered in terms of clause 15.
But already,
Then, and unless you put that to challenge, I as a coordinate bench
Lordship,
would have to follow that.
Lordship, just after some time, Lordship, I have one judgment where already the division bench of our court has already decided on this.
Okay, you bring it.
I'm just bringing the
No,
judgment.
no, but in any event,
Lordship,
this court cannot sit in appeal over the decision of another coordinate bench. You have
Yes,
to, you have to go in
yes,
appeal.
Lordship.
You have to go
But
in appeal.
immediate hardship and all these things, Lordship, how they
No,
have
that is a-
survived,
no,
Lordship,
that is
these
a
things
different-
are also.
I am not on that.
Yes,
I'm not on that. I am on the question of which OM will apply.
Lordship,
Is because this court has already said that 2015 clause 2015 OM clause 15 should be made applicable. Should be applied. Correct? Other departments
Lord,
should be applied. Now, as per NC Santosh's judgment, 2015 OM cannot be applicable in view of the fact that the consideration of the application was
Yes.
done in 2030.
right, yes,
In that case, what can this court do? This court cannot overrule a judgment passed by a coordinate bench.
Yes.
However, it would not be proper for this court also to pass any order which is in violation of the Supreme Court judgment. So the best
yes,
Court.
Lord.
I think would be for you to go to the division bench and clear up this.
It may be that the matter was not before your lordship, that's why the judgment order was passed, Lord.
It doesn't
Yes,
matter
Lord,
whether
it may-
before we or not.
Yes,
Is
Lord.
there- We are all the,
Whatever
this
it
is the
Lord.
High Court and
Yes, Lord,
whether A, B and C doesn't matter. So that is the issue.
lordship, can we take up after some time, Lord?
Okay, after some time, but because I want to see that judgment, that's it. Mr. B. Chetri, but probably we'll have to adjourn this matter.
I do.
Probably, most probably. Can you give me I'll adjourn it now itself.
Lordship, I have the hard copy, Lordship, I just have to
Yes,
bring from the.
okay, okay. We'll take it up out of time. Next.
Item number 44,
Yes,
Mr. RM Das was supposed to appear.
Yes.
He is not keeping well, Lordship.
okay, okay. Okay, right. Adjournment prayer has been made on behalf of Mr. R.M. Das, learned counsel for the petitioner, who is unwell. What about the review petition? Has it been decided?
Lordship,
Accordingly, let this matter after
a week,
a week.
so that's it.
My lord, in this matter, we are moving from pillar to post for pension. The judgment is of 2021, my lord. My lord, on last occasion, the Dibrugarh University was told to take the payment.
Who was to make payment?
And money is to be released by the finance department. The payment is to be made by the Dibrugarh University.
Dibrugarh University.
No, my lord.
Huh? Pension?
Yes, my lord.
What is this? 1,800?
18 crore. 18 crore. 18
Oh, 18 crore.
18 crore is the yearly requirement. Now, according to this letter, my lord, the approval is awaited at the end of the finance department.
Finance
Give it
department?
Immediately.
Huh?
Their finance department is supposed to give it immediately.
Who is the finance department? Are they parties here?
Yes, yes, yes.
So lordship may follow that after 2 weeks, so in the meantime, we also.
Yes, Mr. Kaliha, we want you. We want your money.
Lordship. Yes, Lordship, this proposal was at 19th, Lordship, may grant me some time to find out that it's to go to the paper panel.
I noticed that. Very, very
Yeah.
smart.
Enough of time has got my lord. They should do the right address. They should take the paper. They're all people are dying. Any of
Not dying, but yes, they're not eating the things that they deserve to eat. When can you give us some?
Lordship, I will provide you, like, I will provide.
Next week.
yes, next week, Lordship, give us a short date. I'll find the status.
Next week.
report.
Okay.
Let it come up on Wednesday, my lord. Let my learned friend ensure that from their side approval is.
Yes, Lord.
Mr. K. Gogoi, the counsel for the Higher Education Department, has submitted a letter dated 22/9/23, issued by the Joint Secretary to the Government of Assam, Higher Education Department, which is to the effect that the department has forwarded the proposal for financial sanction of rupees 18 crores for payment of pension to eligible pensioners of Dibrugarh University to finance bracket EC dash Roman 3 bracket close department wide number FS dash HE dash 2023 dash 24 dash 00105 dated 19/9/2023, 19/9/2023 for concurrence/approval. And that the proposal is pending in the finance department. Full stop. Next paragraph. Mr. A. Chaliha, learned counsel for the finance department, submits that he will obtain instructions with regard to the above.
Lordship, I place it on 3rd of October, Lordship, I will, Lordship, because we won't be sitting over it.
I pray that the matter may be listed on 310.
3rd October.
310. List the matter on 310.
We'll expedite the process from our.
In the meantime, if possible, they will release it.
Yes, Lordship, will.
That is there, but let us,
That
let
will
us
not be
get-
Lordship.
it will not be done. No one appears for the petition or the cause. Petitioner was to take steps for service of notice upon the respondent. White order dated, white order dated 30/06/22. However, no steps have been taken to submit para. In the interest of justice, leaves the matter after the vacation. No steps have been taken by the petition. Right. As per the last order dated 21/6/2023. It has been recorded that a notice had been sent to the petitioner by their counsels. By his counsel. Intimating their decision to withdraw from the case. Accordingly, 6 weeks' time had been provided to the petitioner to make alternative arrangements. However, no one appears on behalf of the petition till then. Ms. A. Talukdar appears for the state response. What to do? Right, as no one appears for the petitioner. It appears that the petitioner is not interested in pursuing the matter. The writ petition is dismissed for non-prosecution. If he comes, we will restore it. That's the only way out.
As there were lawsuit status is completed upon resolution number 7, 8, and 9. That's my last order dated.
Who is the query for 7, 8, and 9? No one. What is this matter about, madam?
Regarding departmental inquiry, Lordship, but they have not moved and nothing has been done in this case, Lordship.
What is to be done? Have you come
Oh,
here
then
to
I don't-
argue the matter, to adjourn the matter?
Fix another.
It will-
You have come here to ask to fix another date.
Yes.
For what purpose? Why should we fix another date? What will you do on the next date?
I got to my CPO will appear here. On this.
He will argue the matter. Okay, right.
Because restoration is beginning.
Huh?
Restoration application,
What? No,
but nothing has been here, huh?
no.
Restoration done. Then they have to
Item
move it.
51, item 51, madam.
Yes, Lord. Notice it is. That's the number. Okay.
Petitioner is represented to start. Miss M. Bhattacharjee appears for
And
respondent
appear for
number
1 to 6, Lordship.
1
but
to 6.
Let's be ready.
No one appears for respondents number 7 to 9. Are you filing? You have filed, I think, affidavit.
No, Lordship,
No.
no, Lord.
Are you filing?
Yes, Lordship will be filing. 4 weeks time, I can't be done.
The same respondents are granted 4 weeks time to file affidavit in positive. This is the matter of the court.
Number 3, 4, and 5, 6. 5, 13.
So what do you want? The petitioner's counsel, Mr. S.K. Roy, is granted 3 weeks time to file affidavit in reply. This is the matter of the case.
Office for the 19 and 2023. The notice upon account but we after the content. And my account 1 and 3. No, what is the content?
What to do?
So I will take the step on account number 2.
What about 1 and 3?
1 and 3 not a return rate. The answer notice for the return. Only 2 is return.
Right. Office note indicates that there is no return of AD card or unserved notice from the respondents number 1 and 3. Further, the notice issued to the respondent number 2 has been returned back unserved with the postal remark, inverted commas, addressee left without instructions, RTS, inverted commas. The petitioner is granted, petitioner will take fresh steps for service of notice upon only upon all the respondents within 3 days. This is the matter of the police. Kindly observe.
Find the order page 11.
No, what is to be done here?
My lord, the order has been complied with, my lord.
Wait, wait.
The speaking order has been passed, my lord.
Just wait, wait. Is it okay? Order is complied with.
My lord, there is a direction to consider his case and to pass a region order, say, fresh
Okay.
order.
Right, Mister, what is your name?
P. Dole, my lord.
P.
Dole,
Dole, appearing on behalf of,
Mr. PT.
this item number,
54.
appearing on behalf of Mr.
PT code.
V.D. Kumar. Learned counsel for the petitioner. And Mr. D.P. Bora, learned counsel for
Respondent number 1, my lord.
1. Subject that the order dated 22/6/2023 passed in WPC number 2192 of 2026 has been complied with. Right?
Right, speaking order passed by,
Speaking order dated
order dated 19/8/2023,
19/8/23 passed by
the respondent number 1, my lord.
the respondent.
Right, number is also there.
By memo number
Memo number MER dot 250347/107.
once more, just say, once more, this is the memo number
MER, small cap, my lord, dot 250347/107.
okay? Okay. In view of the contempt petitions accordingly closed.
Okay.
This contact petition is filed a lordship for
Huh?
violation of the order dated 22/5/23. The relevant portion is at page 13, your lordship. Paragraph 10, paragraph number 10. That has not been provided. And we have intimated
Yeah, where have you intimated? Where is the letter?
that is at page 19, your lordship, in that
Page 19.
additional affidavit.
Additional affidavit, page 19. Where is page 19?
And that was received by the respondent on 5/6/23. That is at page 21 of the tracking record.
But what do you make of this order passed for 7/9/23 by this court?
Directed to file an additional affidavit, your lordship.
Forwarding letter has not been annexed. So how did you,
That is what I have done in the additional affidavit, your lordship. That is the,
this is an additional affidavit?
that is at page 19. This is the forwarding list.
Okay, right. Heard, Mr.
Awesome.
R. Sharma, learned counsel for the petitioner who submit that the judgment and order dated 22/5/23 passed in WPC 6880/2015, comma. No, comma, by which the pensionary and other retirement benefits were directed to be released to the petitioner within a period of 60 days, comma, has not been complied with. Issue notice returnable in 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD within 3 days. This is the matter of the police.
Okay.
Hey, Peter. First, the court order is at page 8, sir. In either page 8, next array. 11 part is at page 12. Just lordship are honorable court directed the finance department to examine the proposal lordship and lordship in the view of the matter discourse. Therefore, dispose of this is done with the direction to the finance
Mr.
department.
H. Talukdar, learned counsel for the petitioner submit that the order dated 20/02/2023 passed in WPC 5484 of 2020 has not been complied with. Issue notice returnable in 4 weeks. Petitioner will take step 3 days. This after 4 weeks. I'm like, so what correction do you want?
Managing Director Food Corporation of India, it is respondent number 1. It is we change it. Food Corporation of India.
Yesterday we had passed an order. similar order.
Different place.
I know, but what was that order? You got it, you changed it. Same. You are appearing, you were there also yesterday. Same. Okay, done.
And the
And
main case is here.
And in the main case, FCI, madam, how much time? Same, I think, same order like yesterday, same order. We give them time to file written affidavit in the police. No, I disposed of.
Earlier, they were also given the order that we think Leonard District Council FCI is directed to have record.
The FCI can produce the records on the next day. Right? Put that. Yes, madam, what is your case?
Lordship, it is I for correction in the court cycle of the
How?
Lordship, come to para 2 of the file.
Yes,
Lordship, in this petition, petition number 6 name is incorrectly recorded as a Abdul Ritaken Khandekar. It should be Abdul Batten Khandekar.
correctly in recorded as Abdul,
Abdul Batten Khandekar.
yes,
And
Abdul
after that,
Betaten
Lordship-
Khandekar,
Yes, Lord.
but it should be actually
Actually,
Abdul Batin Kontakar. Okay, okay.
And Lordship, come petitioner number 8.
Ah.
There, Kusmahmud Ali.
Kushman Ali, his name should have been
Ali.
Kush Muhammad Ali.
Yes, yes.
That's all.
No.
Oh, there's more.
Yeah, good. Come to para 3, Lordship.
Para
Petitioner number 5 and 6, Lordship.
Yes.
Ratul Kumar Bora and Montu Bora are working under Executive Engineering Kolia for Kolong Irrigation System.
Yes.
But in the main petition, it should be recorded as a Executive Engineer Nagaon Irrigation District. It should
Okay,
be-
so basically, okay, then what else? Okay, so basically, it's with regard to para 2 and 3.
Yes.
Okay, right. No objection, I think. Look. Heard Miss
MS Emerald.
MS
Emerald.
M. Roy.
Roy.
MS M. Roy.
MS means Miss.
Oh, Miss. I thought what a long name. Miss.
Monica Roy. Short name, very short.
Okay. Say that M. Roy, say MS, can be Messrs or it can be also. Heard Miss M. Roy, Learned Counsel for the applicant. Who submit that some correction needs to be made in the cost title of the parties as referred to in para 2 and 3 of the application. Mr. Ms. A. Talukdar, appearing for 1 and Mr.
I am from 3 to 8, 9 lot.
Mr. A. Chalia for 2 and Mr.
And
Upadhyay Upadhyay for
3 to 9.
3 to 9. Submit that they have got no objection to the application being heard. The correction sought for by the applicant in para 2 and 3 of the application, which is reproduced below, is allowed. Para 2 and 3 of the application is allowed. The petitioner, the applicant shall file corrected cost title with the registry within a week.
You know,
Within a week. As accordingly disposed of.
I know.
Copy can also be
The corrected copies of the cost title should also be served on the council for the response. All right.
I have.
In the main one, what to do in the main case? Are you filing any affidavit? Miss A. Talukdar for respondent number 1 and Mr. N. Upadhyay for respondent number
3 to 9.
3 to 9 are granted 4 weeks time to file affidavit. I think I don't know what.
Lordship, I didn't get the hard copy by, but this case very recently of June 2023, Lordship.
Ah.
Bank of Baroda versus Baldev Singh, Lordship, where the same principle has been used. It has to be from the date of the deceased employee, the scheme prevalent at the time of the death of the, yes, Lordship.
No, but whom, by whom? Supreme Court.
Yes, Lordship.
How many judges? How many
These
judges?
are 2 judges, and here NC Tontos has been referred also.
That is the problem.
NC Tontos has been, and the spirit of that judgment
No,
has been taken.
in any event, in either of the judgment, 2015 OM cannot be considered. So that the best thing for you to do
No.
is please go to the division bench and clarify, and you have got to challenge the order. Otherwise, it's going to cause confusion.
Lordship, this is very much because there are a number of cases, but the other benches, Lordship, on last week, many cases has been dismissed on that ground, Lord. Many cases.
No, but out here, how can I dismiss? it? There
Lordship.
is already a judgment of a coordinate bench. Where's the question of
Lordship,
sitting in appeal over coordinate bench order?
but Lordship may record my submission and accordingly. If your Lordship is disposing the
right.
matter.
No, I'm not disposing. I'm not disposing. I'm,
Okay, Lord.
right. Miss M. Bhattacharjee, Learned Counsel for the State Respondent Submit. That a challenge has been made to the order, judgment and order dated 30/01/2023, passed in WPC 1646/2021 and 7947/2019, white WA number
Uh,
87. 87/2023,
57 of 20.
257.
Wait,
287 of 2020. He further submits that in terms of the judgments, the various judgments of the Supreme Court, the latest being, yes, what is the
Oh, yes, Lordship, I am getting. This is civil appeal number 624,
latest being civil appeal number
2017, Lordship. Bank of
624/2017,
17, Bank of Baroda and others versus Baljeet Singh.
which was disposed of on
And Lordship, disposed of on 21st June 23.
the office memorandum providing the mode for appointment of compassion ground would prevail. No, would have to be considered. No, the office memorandum which was prevailing at the time of the death of the government servant would have to be considered. Would have to be considered while deciding whether the applicant should be appointed on compassion. As the petitioner's father, father had died in the year 2013, the 2015, 2011, and the OM dated 1/6/2015 would not be applicable, would not be made applicable while considering compassion appointment of the petition. He further submits that in terms of the judgment of the apex court in NC Santosh versus what is that?
State of Karnataka.
The state of Karnataka reported in
Reported that
What did it say, sir?
2020 judgment, Lordship.
reported says so, the OM prevailing at the time of consideration of the time
27 SCC 617, Lordship.
20,
27 SCC 617.
the OM, the office memorandum, the OM prevailing at the time of consideration of the application for compassion appointment would have to be applied. However, in the present case, the TLC having considered the petitioner's application in the year 2013, the OM dated 1/6/2015 would also not be applicable. That's all. List this matter after 2 weeks. It,
If not applicable, then clause 1 of 2015 will also not be applicable.
correct. Not applicable, that's
Yes.
right.
And otherwise,
But the thing is, this court cannot decide this case. Because I would be sitting in appeal over coordinate bench. And if I pass a judgment as per the coordinate bench order, then actually I would be in a way not following the law laid down by the Supreme Court. So the only alternative left is for the state to go before the division. So to clarify the issue.
Well, that issue of the record, that issue we raised.
Ah.
There are two sets of this compassionate approach. Before the single judge.
Yes.
Then after a lot of arguments, we also placed the judgment of 2023 itself, 22-23, where it has been said that division bench judgment, where it has been said that from the scheme will be applicable on the death of the person. That state of Karnataka something.
There's a lot of judgment.
On the death of the person,
Correct.
that scheme will be applicable.
Correct.
That was we have we placed the judgment matter. But ultimately, because of the NC Santosh, the Honorable Court has taken into a different angle, saying that no prevailing scheme. That is
But that is why that can be clarified. That can be clarified by the division bench, but me as a single coordinate bench, I cannot do anything.
and to that extent, my lord, had there been that as your lordship expressed the view that 1615 person who died prior to 1615, had that been that view was taken by the single bench, then certainly in my case or other cases, around 20 or 25 cases were there. Their cases would have been considered because this clause 1 of 2015
Not there,
will
not
be
there.
there.
Correct. That's what I'm saying.
That part we argued, but ultimately we have been mixed up with the NC Santosh case. Even the government advocate also gracefully
You
argued.
see,
Could have to take
that is also another problem. Because there are, I think, around three division bench, I mean, 2 judges bench of the Supreme Court who have said that the scheme prevailing at the time of death, that would prevail. NC Santosh says, 3 judges bench says at the time of consideration, that would prevail. But subsequent to NC Santosh, there are again 2 judges bench who have referred to NC Santosh, but still said that the scheme prevailing at the time of death. Now it becomes very confusing for us.
Yes, yes, my lord. Probably I also I remember, my lord, in earlier occasion I placed before the Victor Lordship that particular term instead of Karnataka. And somebody, government advocate, have no, NC Santosh will be applicable to and so. Lordship in Lordship court, it was case fine. I placed the case.
I think I have in one judgment, I think I have relied upon the judgment passed subsequent to NC Santosh. The Supreme Court judgment, 2 judges bench, which referred to NC Santosh, but still went with the proposition that the scheme prevalent at the time of death would prevail.
But
And I
yeah.
So-
But we are well, at the time of our argument, my lord, we were totally confused, my lord, which has to be followed.
what to do? What to do? Yes.
Before starting, my lord, I have received the copies, my lord, complete set today, my lord. They are the third party, my lord, not writ petitioner. I'm the writ petitioner, my lord. They are not party. They came for review, my lord.
Sure.
In the meantime, my lord, I could they are the stranger, my lord, for the filing objection in the leave petition, my lord. Sometime may be granted to me. Because, my lord, today at 1:30, I have the entire set of copies.
No, it's a question of law, Mr. Counsel. It's not a question of
Yes.
fact. It's
Even otherwise, my lord, by this time, my lord, by persons to your lordship's order, my lord, the comparative tender process has already been initiated.
maybe. Yes. Yes. What judgment are you relying upon? No, you just tell me. Just tell me. What is that thing? Return. Ram Janam Singh.
Hello?
Division Howbam Singh. Howbam Sunil Singh.
No, it is Corona, so. Division. Two and three, my lord.
Korean Joseph something. This is what? This is which? This is
Himachal.
which court? Kerala High Court?
Yes.
For what?
No, no, you must put.
Huh? Himachal Pradesh. Himachal Pradesh High Court. Okay.
There are two, my lord, according to the petitioner, he is not a party to the petition, though he is one of the. affected
Anyway.
parties.
No, I'll give you a better judgment. There's the division bench judgment of our court.
My lord,
That is true, my lord. Here, my lord, what happened, my lord? The petitioner number two, his father is a businessman, my lord. Another society.
so what?
Apprehending, my lord, he'll not get, that's why he came.
No, no, no. He
He filed another petition, that was also withdrawn, my lord.
The son may be of the other person.
They filed a petition that is
Son may
withdrawn,
be
my lord.
in one
In the hearing
political
this.
party, other may be one.
very,
What will
very.
you find?
I'll
No,
file-
no. Their case is their case is that there are some
Tourist guide.
Huh?
It's a
Tourist guides. and you want to preserve that area. Basically, they want to preserve, and then you file a writ
And in
petition.
fact, my lord, we have filed the other
Go for
petition.
What has happened to that writ petition?
It's pending, my lord.
Pending. And
At the time
Well,
of
in the-
hearing of
in-
the
in that
petition,
writ
my lord,
in that writ petition, were they parties?
I got impeachment, my lord.
Huh?
I got impeachment.
Or you got impleted there in that part, in that case? When did you get yourself impleted?
No, no, that file I did not.
Okay, now if you got yourself impleted in that case, while this court had disposed of the subsequent writ petition, why didn't you make them parties?
My lord, they are not party, they are not a businessman, my lord. They are nothing, my lord. They are,
No, but
no. Prior to that, your lordship has passed the judgment.
prior to that.
Prior to your lordship pass judgment, go for tender process and you should come. Somebody is enjoying on a daily basis, your lordship pass order, go for a tender. Transparent. In the meantime, my lord, they file another complaint, they filed a complaint, then.
They are
order-
saying that they are tourist guides. They are not doing business. That's what they
No, no, they are not tourist guide. Tourist guide and they are not related to cooperative societies. Not they are related to my lord. This is not a PIL, my
make
lord.
a statement, I don't know.
That is not a PIL, my lord.
Anyway, what we'll do is we will not pass stay. We'll allow them.
My lord,
to-
lordship give me only 1 day time, my lord. I'll give my objection by tomorrow, my lord. Lordship fix the matter on Monday. What techniques they have done. Please representation totally before your lord.
My lord, before that, my lord, it may be allowed, that it will become,
I'll file, my lord, for leave, my lord. Lordship give me only 1 day.
people may be numbered and it may come, it may come on Tuesday.
What does it matter? I will not give stay. I will not give stay in the review.
My lord, even though, my lord, they are not suitable, my lord, they have vested interest that for their.
People may be
How will, you see, how will I know that now? How can
That's
I?
why I'll file affidavit, my
No,
lord.
because their affidavit, you see, there will be a disputed question of fact.
No, my lord, on record, I'll keep. No disputed question of that. What they have done,
What have they done? You tell me.
they have filed another writ petition.
Ah,
That, my lord, just.
in that writ petition, what is there?
They are saying, my lord, they are,
What they-
that fishery shall not be allowed
Why?
for running any kind of commercial activity.
Ah,
That case, my lord, they said it falls under Dibrusakya National Park.
Ah.
The honorable court said, my lord, no, this is not within the national park, it is outside. Honorable court, 14th bench passed a deliberate judgment. Then hearing them, my lord, honorable court about to dismiss their case, they have withdrawn. That petition I want to bring. Then lordship will see their local. Then lordship only a 1 day time because that very file I did not bring and only today only I received the copy. Then your lordship will see whether they are entitled for the leave or not. Suppression of fact, obviously lordship will not allow. And for their vested.
Have you withdrawn your writ petition?
Like we had filed a second writ petition, my lord,
Is that?
for being included in the case file and.
No, madam, there is another thing. Have you mentioned that second writ petition here?
Yes.
Huh? Yes. Okay, when can you file your return?
Yes,
Three days time may not be given.
You said tomorrow.
My lord.
Tomorrow, my lord, tomorrow.
You said
is
tomorrow.
Saturday.
Para 21, my lord.
Tomorrow is
Para
Saturday.
21.
Para 21.
And we have annexed the of my review.
Para 21.
Yes, my lord.
Delay is also there, that also not been considered.
Para, there's no para 21, madam. There's only,
29 of the review. Annexed, my lord.
give me the review petition. No, you see, where is it in your pleadings here? You cannot
My
go like.
lord, this is the application for leave.
Correct, but then you have got to bring out facts as to why you are a necessary party.
I expected in the review.
You have stated in the review.
In details, my lord.
Where? I have got the review in front of me. Where?
There are 20 of that, 21.
Para 21 of what?
21 of the review.
Of the review petition. Not in the IA. Okay, para 21 of the review. But you have got to put it in the thing.
But the review petition of my lord.
21 of the review.
Yes.
File WPC 3548 of
Okay.
2020. This should be in your IA.
Actually, my lord, we filed
Also.
that second lead petition, my lord, following 9 by 7 times. Judgment of the honorable Supreme Court. Subsequently, that has been reviewed.
You see,
That's
this,
why when the court pointed out, my lord, we were given.
Tender process is already on.
Yeah, my lord.
what about this 2374/2022?
That is pending, my lord. In that case, my lord,
Madam, there is two writ petition. Please understand.
Yes.
One is 2374 of 2022 and one is 3548 of 2023. Both of them are pending.
no, 354, we have withdrawn, my lord. That was.
Yeah, we don't. Which one?
3548.
Yeah, we don't. But 2374 is still pending. Is it?
And government advocate.
Yeah, Yes, they just see, just give me the order, madam. Rakesh. WPC 2374/2022. Just give me the last order.
That petition is
Long one? This is the 22.
Yes, my lord. Oh, that was passed on 1452.
Who is the newly respondent number 10, Mr. Barbuya? Oh. And,
My lord, today the leave may be allowed. And review petition may be registered. If he has any objection, he can file.
Tell me one thing, in your case of 2374 of 2022,
Yes, please.
who are the parties? Are the parties in the disposal of WPC, in the WPC that I disposed of?
Yes.
Are there any common parties? No,
Government not there, my lord.
no, common, COMMON, not government.
Lordship can see page 80, your review petition,
Page 80.
80, operative part, it starts from 75
People
of
have
the
already
review
came
petition.
there for the paper.
Yes,
These are the one petitioner and I am the petitioner in 520, 876. Then operative part your lordship asks to complete the tender process by 15/7. Tender has been initiated, comparative statement also made, now about to give the final. All these chapter has been. I have got a comparative statement, if your lordship participate, I can supply. I'm
no,
just-
but what about their stand? I think we'll hear them out.
Earlier this petition we had filed, my lord, in view of the recommendation of the committee constituted by the government to define and redefine the river fisheries according within the national park, my lord. The committee
So whether
recommended
we'll have
that
to see whether it is in a national park or not.
It is decided by our coordinator, not within that.
not like it.
That's why, my lord. That's why, my lord. That's why,
The
No, I
reply
don't-
order has been given, my lord, it is not decided, the case is filed by the state is pending.
It is a interim order has been decided. The interim order
Interim
to
order
what effect?
first, my lord.
To what effect?
to go for tender process, your lordship's order.
No,
was
no,
come.
that is not
In
an
view of the
interim order.
Passed by the honorable court of the South India. I'm so down. At the time of filing of this, the review petition that order of court. WPC number T457 of 2023.
Huh?
3457 of 2023, order passed on 23/6/2023.
What does it say?
Apart before reading the law. It's an easy order, let's say, it's any. Para 14, it says, as the court has no doubt that the eco-sensitive zone must be restricted and protected at all costs. It is provided that in the event any of the respondents are able to demonstrate that any boundary or the eco-sensitive zone of District overlaps with the boundary of diplomatic point, such respondents would have the right to apply for modification of this.
Is that here? Is that a
When the restriction finalized order was not available, so we have undertaken to produce the order at the time.
let me see.
To that effect, my lord. Because I have not, copy was received today only, my lord. And central government also notified. Bond.
Right. Argument on the review petition may be asked later on. Today, my lord, my prayer is the let the leave be granted to us
Locus, my
and
lord. has
office
to
may
be-
be directed to register the review. Then he can file his reply, whatever he wants to say, that he
I want to file a-
after hearing that he can decide it.
What is this operation of the letter dated 23/5/23? What is it?
We have annexed my lord. In the review.
That has been, my lord,
There is 82 my lord.
part. Oh, regarding this is the part.
After a stage, the committee decided that the stream whole area in question is not viable for commercial fishing. Moreover, the stream ultimately passes through Maguri Matkum Bill and where commercial fishing cannot be allowed. Thereafter, the boundary of the same hole has been redefined.
Just a
by-
minute, just a minute, madam, just a minute.
Most probably this is state, my lord, in my petition. They got a name. They are state, my lord.
It has
This
been-
state,
This letter has been stated.
after hearing them also. That is not enforced, my lord.
It
That's
is
why, my lord,
enforced in
one
the
day-
review petition.
One day or 2 days time be granted, my lord. Then their intention will be.
This court by order dated 15/5/23 at dispose of WPC 520. Is this my order?
Yes.
That this petition is under review.
I-
Then thereafter, my lord, the
Just a
government has
minute.
Yes, lordship, I got the order. for state. Lordship can see that there is that one they have, let's only pardon me, my lord, I am giving copy like. The very letter relying upon has been stated.
not only that, petition. Don't use that word. We never do that. Petition is very strong word. When you apply that word, no, you have to check.
That is the order, my lord. The on the coordinate bench has stated the letter.
Also, we have annexed everything in the review. petition.
Where is the connection?
Where is the?
Lordship, under by Surata passed the order stating.
Where is this letter?
Page 82. Of our review. petition.
Of a review petition, everything is there in the review.
That is state.
I have stated everything in the review. petition. If there are 20, we have stated particular to state. Only I can speaking remote. And thereafter, the government, thereafter, the government has constituted the committee one to go through everything, my lord.
Lordship, for a moment, lordship will see
Page
just a moment.
86.
The holding page, my lord. It was heard by him, yes, my lord, order. Order the 25 that
We
has
have
been
stated
stated.
everything.
Yes, so
I have 22.
And it is not stated in the review petition anywhere. That order lordship is there. The
My lord,
25,
we have stated in
25
paragraph 22, Lord, I have already pointed out.
then no, my lord, it is not stated, my lord. In the open court, I'll say, my lord, in the live.
anyway, since these issues have been brought, I think we'll Let them join in. Let us see.
Lordship will see before that order, my lord. Just give me 1 day time, my lord. Lordship fix the matter on Monday. I'll bring to judge.
What judgment?
My lord, they have participated
Participated where?
in the writ petition, my lord. In my writ petition, which the honorable court take that. They are
On the very first day, I appeared as a caveat, my lord. Without without our reply, my lord, on the same day, court has passed the order. We have stated in paragraph 2, how we can stay. We have stated that for please notice and stay the party in order. So, it is an undertaking.
You can file the objection in the review. We won't stay the review. We won't pass any stay order.
my lord, the ultimate intention is to delay process the pen.
That should no. The ultimate
I will-
intention is to ensure there is no fishery. There is no fishery.
There is the
I'm
the
not a
honorable court
fisherman.
declared, my lord. This
Huh?
order has clarified, my lord. Central government has also notified. They published map also, my lord. Outside the boundary.
It
Our
will be
order is there,
decided
my lord.
after hearing, my
Huh?
lord. We are objecting.
There is already a notice that calculator to be held that if the high of the boundary, it is redefined after the declaration of the notification, that has no immediately to the ecosystem. I want to discuss of ecosystem. Always please.
Where?
That folding page, lord.
Folded page. What folding page?
My lord, I have folded, my lord.
Yes. You have folded so.
Lordship will see
Yeah.
2018 or 18.
tiny.
You see, madam, it says here, the learned state departmental as well as learned senior counsel for the newly imputed respondent. That is you.
Which case?
That is in WPC 3457 of 2023. The
We
order
appeared,
passed on
for
23/6.
the caveat.
The court implemented that.
Yes, it is
We
you
have appeared,
appearing.
we have
Yes,
explained
it's
so.
you. It's you. For the newly imputed respondents have,
Decided only in same order, my lord. We have
Madam,
filed an
madam, one
application.
thing. Have not been able to show that any of the coordinates of for the Dibru Nadi Part 1 fishery mahal touches upon the boundary of the eco-sensitive zone.
My lord, here is not a question of boundary. If your lordship can return to page 51
Of
of my review petition.
why is everything in your review petition? It should be in your application to file a review.
Well, that is for the fair, my
You
lord.
see, you have got,
Allow me to
no,
find that.
madam, you
You
have got to show in your application to file a review that you were a necessary party and you should have been heard. Now for that, you have got to put everything in your review to satisfy the
That is
court.
why we have given everything in the review petition.
No,
Now,
sorry.
as the administrative case, I have
That
filed.
is
or
not-
they
sorry, then-
required me to file the
But
review
then
petition.
if I don't allow the application, there's no question of going into the review. If I do not, if I'm not, you see, unless I'm satisfied that you should be given leave to file a review, Where is the question for me to go into the review?
Might give it a prayer for review, my lord, because I. have
Mr.
already
J.I.
told-
Barbuya, learned counsel for the respondent. Is granted how much time?
3 days.
3 days time to file a written objection to the application.
My lord, they have
Let
already
the-
filed
the
the
matter-
objection, my lord.
Huh?
They have already filed the objection.
I got copy
Where?
today only. How?
Where?
can I-
Where are they filed?
There is a day of file objection. my lord.
Huh?
They fall in,
It's not before me anyway.
this is the following.
This is this is something different.
This IA is in 520, madam. This is on the disposal of case.
In the legal application, they have filed that.
They file objection in the legal.
When? It's not here.
From where?
That's your copy.
Yes.
Okay. When did you file?
Obligation.
Oh, yes, yes.
Oh, yes, yes.
I just received the copy today, madam. We teach on Monday, Thursday.
Okay, but the
My
thing
lord,
is,
my
it
leave
is not
may
here.
leave may be allowed and.
Anyway, it is not in my copy. I don't have it now. No, anyway, whose copy is this? Your copy. So your written objection is here.
This volume, my lord.
Now we'll go through it. Where is it? Ah.
Daga, एक copy. No, no, why did you- I got-
Yes, this is the one. We have filed.
That's what I'm looking, my lord. But I have no well,
No,
supplying, my lord, I did not see this now.
But then you were asking for time to file.
Oh, my lord, no, no, not the matter. Be heard, my lord.
I'm hearing you.
Yes, yes. Lordship will see. First, my lord, lordship is take up, my lord. I'll go by chronologically, my lord. Lord will be convenient for this honorable court to understand, my lord, what is the fault.
That will be hearing of the review itself.
No, my lord. So for objection given to them, their locus standi, I will take up.
No, there's nothing for you all to say. I can read it myself. You're not going to say much beyond what you're.
Yes, yes, my lord. They are, my lord, running business, my lord, page 46 and 47, my lord, of fishery, my Mahar. Father of the petitioner number 2. Prasanna Kumar Das of the petition.
Father of
Review petition. They are joint family, man. They are joint family. Their father is a fisherman, son is staying in the same house, running boat. They are also, FPL was there, my lord. I filed FPL.
So why do they want this fishery to be stopped?
They, my lord, his father is the secretary. He doesn't want I should grow. They don't want I should grow. They want, my lord, monopoly in the Tinsukia district. They got, my lord, lordship, I'm coming that matter. How his father is done.
Possible.
Possible. And, my lord, they are running, my lord, they got a ferry guard also. Father of the petitioner number 2.
Got a ferry guard.
He's a ferry guard also. Boat also. Then, my lord.
So and he's looking after that
No,
that bill also.
not
He's a secretary.
Bill is the outside.
Okay, not bill.
Bill is the outside.
Okay, bill is out.
Outside. Then, my lord.
He's looking after he's looking after that fishery also.
Yes.
He's the secretary of the fishery.
Yes, father is the secretary of the another picture, plus member of another picture, 2 picture. That I'll come, my lord.
So this is all to do with fish.
Yes, my lord, he has not come the clean hand. Bona fideness has to be there, man.
Huh?
Bona fideness has to be there. They want to stop, your lordship has passed order, go for a settlement. They said this cannot be done because of it is eco-sensitive food. Honorable ordinate bench said it is the outside the food, outside the eco-sensitive zone. So your lordship's order was confirmed. Confirmed. Go for
No, that was you mean to say stay order was given.
Yes, sir.
Not confirmation.
No, there is like observation is there. I'm coming.
Anyway, we'll take it up at the last. Let's finish the other. Let's finish the other.
Lordship, on the last occasion, we were asked whether we have informed the private respondents or not. Lordship. We have informed them, Lordship, and I have the Lordship report of it. So we have,
Can you give us the report?
Lordship, but it has
Huh?
not been signed, Lordship.
Huh?
They are already informed, Lordship.
They are
All the
already
private
informed.
respondents.
So can you file a small affidavit?
Yes, sir.
We file a small affidavit. Mr. R. Upamanu, D. Upamanu, Learned Counsel for the
Health
Health and Family Welfare Department submits that service upon the private respondents through the respondent number 4 has been done.
and we have informed them.
And that,
It was
only information.
only informed them. If there is a case pending. Lordship,
But what about all the Talabana that he has not submitted Talabana to him?
yes, Lordship. We have filed, it is also filed. On 19/6/2020, we have given everything to them. Lordship.
Huh?
Bring it in the form of an affidavit. So far, last.
Mr. Counsel, be very clear.
Lordship,
Have you informed or given them the copies of
yes,
the,
Lordship, we have given them the copies, everything.
then?
So far, Lajama court order.
Huh?
So far, Lajama court order. 36 complete upon the Ratnam number 5 to 7.
Yeah.
5 to 7. So far, 8 and 9 information of. Where informed.
Okay, right. What have I said? And they have been informed of the pendency of this case. Full stop. He submits that he will file an affidavit in this regard within 2 weeks. Wait 2 weeks. Full stop. The Lavazima court order dated 24/8/23 states that service is complete in respect of the respondents number 5 to 7. Accordingly, notice is deemed to be served on the respondents number 5 to 7. In respect of respondents number 8 and 9, it is stated that stated as follows, inverted commas, addressee not available, hence RTS. Inverted commas. This is a matter after 2 weeks. Why? No hurry.
Public.
Please, Lordship, my lord, in this matter, the service on respondent number 5 is awaited.
Who is respondent number 5?
The headmaster of the concerned high school from where the petitioner passed, my lord. The headmaster of the Kanikuchi Nijpuri.
Yeah, what are you challenging here?
My lord, because there was violation of fundamental right and principle of natural justice, my lord. Because, my lord, the
What violation of what fundamental?
fundamental rights and the violation of principle of natural justice on last.
What
occasion also,
is
my lord,
this? What is this case?
Case is regarding
Downbora, then the appeal was filed.
appeal was filed by a person, my lord, who is not a candidate, my lord. Appeal was filed by a person who is not a candidate.
Then what
And,
happened? Then what happened?
Then, my lord, the petitioner first someone he did not receive. There was a violation of the principle of natural justice. Your lordship, that is apparent, my lord, at page 45, my lord. Page 45.
Just a minute, just a minute.
The same plea was.
Just a minute.
Yes, sir. Sorry, my lord.
Okay,
Your lordship, the order is of the TFC class on 18, your lordship.
so
Review live before the government.
162D.
Yes,
My lord, this fee was taken by the respondent on last occasion also, and I relied on the judgment of Harbansal, Sahania, and another, my lord, where it was stated, my lord, when there is violation of fundamental rights of the petitioner and violation of the principle of natural justice, my lord, then, my lord, alternative remedy, my lord, there is that is the exception. And in this case, my lord, the petitioner, my lord, if your lordship comes to, apart from the other merits, my lord, if
so you did not go before you did not go before the authority.
Yes, my lord. Because there, I did not receive the summon in time, my lord. Because I received the summon after the date of the affair.
Then you go to this authority, you go to this authority.
No, my lord. When there is a violation of principle of natural justice and violation.
It still, just because, you see, that is the discretion of the court. It is
Yes,
not,
my lord. And,
so-
and that's why, my lord.
so I am not exercising my discretion.
My lord, today the matter is fit for service, my lord.
No, maybe, I am disposing,
on
you
the-
can, you have you have got all the right
Yes, my lord.
to go in appeal.
Yes, my lord. But my lord, and secondly, on merit also, my lord. Because the SEBA, I have made secondary education board of Assam, my lord, as a party, so they have also got instruction, my lord. That the claim of the petitioner is genuine, my lord. They have also got the evidence.
But then there is statutory remedy.
But
They have invoked that remedy. If they hadn't invoked, that's a
but
different.
when there is violation of principle of natural justice, my lord, there.
I do not know. That is a
No, my
question
lord,
of fact, whether you
From-
got it, you did not get.
No, my lord, from record it is apparent. Your lordship kindly come to page 45, my lord.
Oh.
Page 45, my lord. It is apparent from the records, my lord. 45, my lord, the summon was issued to the petitioner on 27/6/2023. Page 45, annexure 12.
Yes.
And my lord, the next date of the case was fixed on the date of hearing on the above appeal has been fixed on 36/2023. And if the postal taking report at the next page, my lord, if your lordship, that there is someone was delivered to the petitioner on 1/7/2023.
Where is that?
So page 46, my lord,
Oh,
46, page 46. It was delivered to the summon was issued to the petitioner on 27/6/2023. Hearing was fixed on 36/2023. And petitioner received the summon on 1/7/2023.
How do we know that this 1743
My
is
lord,
pertains to this summons? How do we know that? How do you prove that?
My lord, because annexure page 46, my lord,
Hmm.
Tezpur head office, because summon is of 27/6/2000.
Maybe, Mr. Kausa, how do we know?
What is the record? Because
This is your document. You have got to prove your document. You cannot
I
ask
can
them to
prove,
prove.
my lord, that consignment number I got with my the postal record. With that, I got the postal the tracking report. Page 46, my lord. Page 46, my lord. With that only.
No, just show me. How can you prove from here?
Yes, my lord. Then
You have annexed this document
yes, my lord. Let me see if
to
they,
prove your case that you received it on 1/7/2023. How do you prove it?
let me see, my lord, because my client will have that postal envelope, my lord. Here, or my lord, I will get on the next date. I will. Yes, my lord. It is there.
Number.
Yes, my lord. Yes, my lord. It is there, my lord. That consignment number, my lord.
Yes,
The petitioner did not get any chance to file his written statement or it is
yes.
clearly violation of principle of natural justice.
No, now because the divisional commissioner's office is gone.
Yeah.
So what we will do is we'll set aside this order
Yes.
and we'll send it to the commissioner and secretary who will decide the matter of it.
Yes.
Because now he takes, because of the latest notification, he is the one who is. है ना? Okay, right. Okay. Heard Mr. D.P. Bora, the learned counsel for the petitioner. Also heard Mr. S. Datta. No, who's for respond number one? Mr. J. Handy for respond number one. Then Ms. A. Tarukdar for 2 and 3, and Mr. D.K. Roy for respond number 4. Then
I am for
you just, Mr.
B. Raman.
B. Raman for
That's number 6.
respond number 6. Yeah, for the private respondent. So he got it late. He got it 1 day late.
And one
Say
important thing-
the impugned order is passed on 30th. He got it on 1st.
and one important thing, he doesn't have any local standard. He is not a candidate. my lord.
Oh, he's not a
He
candidate.
is not a candidate.
Yes,
my
yes, I
lord.
was a candidate, my lord.
No, my lord, he is not a candidate.
I was a candidate on the other hand, my lord. On the
Other
date-
end?
On the date of application, my lord, he was minor. As per requirement of the advertisement. he
No, no,
was-
that is a different thing. Look, we are talking about you.
Yes.
We are talking about what you had for breakfast. Don't talk about what he had for dinner. So what were you a candidate?
Yes, my lord.
No, my lord.
Anyway, that you take up
Yes,
there.
my lord, definitely. Yes, my lord.
Okay, you just take this order, long order, at last order. You take all up till you just take, I just take. huh. Five. Okay, after this, the petitioners count, but one thing, after 30th, was there any other hearing?
There was a hearing, that time also the petitioner did not get any notice, my lord. So, but.
No, because the impugned order,
Yes, my lord.
impugned order has
My
been,
lord,
impugned order has been passed on,
17th July.
no, has been passed on 17 July.
Yes, my lord. There was a hearing that was conducted through video conferencing. So the petitioner did not get opportunity to file any written statement or any document, my lord.
When? On 17.
Yes, my lord.
In-
Because it was done for video conferencing.
No, but then you see, then another thing, this is with regard to summons of 1/7.
Yes, my
You
lord.
got it on 1/7,
Yes, my lord.
but judgment was passed on 15/7,
17th.
17/7.
Yes, my
No,
lord.
15/7,
Yes, my lord.
15/7. Memo is 17/7.
Yes, my lord.
So then you had time. You had time.
No, my lord. I came to know about this on my lord for 13/7 or 14/7, my lord. Then only I tried.
No, but then you got the summons on 1/7.
Yes, my lord.
Then
Thereafter, he went to the office. Office was closed, my lord. Nobody was there. Thereafter, after the date, my lord. Office was there. Nobody was there, my lord. And now also the office is not functioning, my lord. After receiving on 1/7, he went there, my lord. Office was closed, my lord. That was not functional, my lord.
So you have been removed from your post?
Yes, my lord, but due to the interim order, I am continuing, my lord. Interim protection has been granted by your lordship, my lord, so I am continuing as of today. And the ground on which, my lord,
Yes, madam. Although no social, the petitioner appeared before the commission
yes,
along
my
with.
lord, he got the opportunity to appear, but he did not get the opportunity to submit his written. That is apparent, my lord. In paragraph 16 also I have stated, your lordship may peruse the paragraph 16 at page 10, my lord. Paragraph 16. I have stated, my lord, there aforesaid summon dated 10/7/2013 only on 14/7/2000 subsequent summon, by which he was asked to appear on 15/7. He received on 14/7. Although the notice was so short, however, on the next day, that is on 15th, the petitioner appeared before the commissioner along with his affidavit. The commissioner of North was not present in the office. The hearing of the matter was done through video conferencing. The petitioner or his advocate did not get any opportunity to participate in the hearing process by producing the required documents. Because on the last occasion, that opportunity was given, which the petitioner did not receive the summon, my lord. So the petitioner was not afforded any opportunity to file his written statement because he received the summons for final hearing. On 14/7, he received 15/7 final hearing was done through video conference.
For postal record, he received on 1/7, my lord.
No, maybe.
Thereafter,
But then the next day,
77.
but then the next day, let him get an opportunity.
Yes, my lord.
It's fair. Let him get an opportunity.
Review of option is there, my lord.
Huh?
Review option is there already, my lord. Can he avail?
You're for the revenue department.
My lord, my lord. My lord.
All of you all are divided in your who you are supporting.
And the private restaurant, that is the government.
Anyway, whatever it is. The petitioners also submit that the office of the commissioner passed an order dated 27/6/2023, by which the petitioners also submit that he was not given an opportunity of filing any written statement or taking part in the proceeding or taking part in the proceeding except for submitting no, except for making submission on
15/7.
15/7
Through video conference.
2023 through video conference.
There was a small computer
Course
in the room, my lord, that was
As such, the impugned order, as the petitioner has not been given an opportunity of being heard, a proper opportunity of being heard, the impugned order dated 15/7/23 should be set aside. The counsel for the respondent number 6, on the other hand, submit that the petitioner had received the summons issued to him and had also appeared before the office of the commissioner on 15/7/20. As such, it cannot be said that the petitioner had not been given an opportunity of being heard. Accordingly, accordingly, no grounds have been made out to interfere with the impugned order dated 15/7/20. I have heard the learned cause for the party. The the order dated 27/6/23 passed by the commissioner states that the hearing of the appeal case number 13/2022 has been fixed on 30/6/2023. However, the
page 46, my lord. 55 and 14.
However, the postal department track consignment document shows that the petitioner had been given summons only on 1/7/2023. That is after the date fixed by the court on 30/06/2020. The subsequent summons issued to the petitioner on 10/7/2023 was received by the petitioner on
14/7.
14/7/2023, and he attended the hearing on the next day, that is 15/7/2023, through with his counsel, through video conference. Through video conferencing.
However, he could not submit any document. He was not
The above facts clearly goes to show that no proper time had been, no adequate time had been given to the petitioner to make a proper submission to the office of the divisional commission. It is the view of this court that unless some adequate time is given to the parties to submit their side of the story, no, their case, for there cannot be proper adjudication of a dispute, especially when the matter involves the disputed questions of fact.
Here, he includes document, here also, to peruse the written statement submitted by the party. Meaning there, he also submitted
No,
written
no,
statement, my lord.
no.
Where?
Here, document, page, my lord, 49, second line, my lord. I have gone through the appeal and also heard the learned advocate and the appellant as well as the respondent. Peruse the written statement submitted by, he also submitted written statement, my lord.
I categorically
How we
state,
can
if
say, my lord, that
if my
he has
statement
submitted
is
written
wrong,
statement?
my lord, I may be input cost. I categorically state, my lord, I was not afforded the opportunity to submit the written statement. Because, my lord, on that day, the divisional commissioner was not also present in the office for video conferencing only it was done. And how he will peruse, my lord? Because on the first day, he did not get the opportunity to appear. On the second day, he appeared. Divisional commissioner was not present in the office at the Tezpur.
But now this, you see, this is now the Supreme Court has, I think, passed an order in matters like this. That of course, that pertains to court.
Yes.
That you cannot question the observations made by the court in factual cases like this.
Yes, my lord.
That-
That is true.
that-
But other facts also revealed, my lord. Because on 10/7 notice. has
No,
been-
then you file an appeal, I think, because he has said peruse the written
I
statement.
categorically state,
You may-
my lord,
you
I
may-
deny, my lord, he has not got any opportunity to file the representation, my lord.
Mr. Counsel, you know what the law is.
Yes, my lord. Because Horvangshlal, my lord, it has been clearly stated, if it is violation of the fundamental right and natural justice, my lord, then, my lord, writ petition can be exercised, my lord.
I'm not on that.
Yes, my lord.
That is one aspect only. There are other aspects. And you see what used to happen when we were lawyers also. When during the prohibition time, these two persons are caught with the liquor, and they will come to court during the CC stage. One will say, "It is mine," and the court will ask the other person, "Is it true?" Yes, it is his. It is not mine. The court will discharge one. Then the other person will go to the High Court or to the Sessions Court and say, "I did not say that it is mine." So you see, they were now, they have changed their stance when they go. So now what to do in cases like this? Now, when the court has made a recording or convicted someone on the basis of their admission made, which they later on deny, then what is to be done by the court? What is to be done by the court? Do we believe them or do we believe the court?
My lord. May I submit one thing?
So that is where
if-
the
if my
Supreme Court has said,
No, my lord.
judge's record is conclusive.
No, my lord.
None can claim to contradict it except before the judge himself.
My lord, may I submit one thing?
So that is
If-
why I'm
No,
sending
no.
it back.
May I submit one thing? If the petitioner would have got the opportunity to file a written statement, then this fact would have come to the knowledge of the commissioner, that his date of birth has been corrected by the SEBA, my lord, and he's 25 years of age. That should have, but that he did. So, second paragraph. it
So,
is
Mr.
shown that the-
Counsel, you go in appeal. You
No.
go in appeal before the.
No, my lord, what I am submitting, that he did not submit a written statement, that's why that fact has not been gone into by the.
But this is a question
Only
of.
one sentence by the parties, by which party?
Okay, then we'll call for the record.
Yes, my lord. I pray
will
that
call
the
for
records may be called for.
Whatever I said.
Everything will be apparent, my lord.
The impugned order passed by the division commission states that he has perused the written statement of the parties, which implies that the petitioner had submitted a written statement.
Parties means my.
Full stop. However, the petitioner's counsel submits that no written statement was filed by the petitioner. Full stop. Accordingly, who will produce the record? Mr. J. Handy. Miss A. Talukdar, Learned Counsel, shall produce the records on the next date. List the matter on. This is the matter after 2.
My lord, interim order may be continued. My lord. Interim order passed earlier, so may continue.
I don't know. There is a.
I am of the same.
No, interim order is there, my lord.
Judicial order is.
Does it mean that it has to continue till kingdom come?
My lord, he is continuing in the post of Gaubra, my lord.
Judicial order has been disputed by my learned friend.
My lord, that is not. He has been continuing in the post of Gaubra, my lord.
The appellate forum as part of this order, he is disputing that statement has
On
not
the
been.
basis of the interim order passed by this honorable
That
court, he is
continue, my lord.
continuing, my lord.
I am
So
objecting.
balance of convenience also. It will
I am
be in
objecting, my
favor.
lord.
Interim order to continue till the next day.
Obliged, my lord.
Date may be fixed. Otherwise, my.
Huh?
Court date may be fixed even. my lord.
No, give a date, give a date. This is the matter on. What is the, I can't see, it's so far off. 9/10.
Obliged.
Yes. Yeah, we'll do it to repetition.
That's it. Item number,
You take your envelope.
may I please your lord? Item number 59 may be released on next week.
Item 59.
Yes, that's it.
What
Hearing
is the
matter.
matter about?
This is a service matter, lord.
Okay, on the prayer of the parties, this is the matter in the next. Then,
Lord, may be fixed on.
What?
Lord, we received the updates instruction in the.
in which item 59,
59.
what is the updated instruction?
The petitioner is a promoted lord.
Promoted? Oh, then what?
Annexure, finance. Lordship can be fixed on 28 lord. The petitioner is promoted to senior grade 2 on 22/1/20 and promoted to senior grade 1 finally on 24/3/2006. Lordship, my senior counsel is argue on this matter, lord.
What is there to argue?
Highly fixed it on 28. lord.
What to do? Huh? What is the prayer in your writ petition? Please read at least the prayer. Try to do something at least. Don't blindly follow what they say. Try to learn.
The respondent to so cause as to why the writ as paid for shall not be issued setting society quashing and impugn order dated 27/6/2016 and 5/9/2016 and after hearing the parties and perusal of the record, the upon cause or causes being so make the rule approved by setting aside the quashing the impugn order dated 27/6/2016 and 5/9/2016. And alternatively, issue a writ directing the respondent to restore the seniority of the petitioner and constitutional benefit as or pass as order or orders specific.
Anyway, this is the matter. On the
Okay.
prayer of the Pentecost Council, this is the matter in the next week. Yes, lucky that photo would make it very short. No need to make it full. Just put their name and that's the what portion I gave you the. Yes,
My lord, why it is after this fishery, my lord? Because one PIL was filed for running illegal business in the Tipru, that national park mine. That your lordship will see just for a gallant's manner. Wherein the father of petitioner number 2 is the respondent. That PIL is at page 53. Then, my lord, his name appears at page 55, my lord. That the honorable court interfered, my lord. Thereafter, my lord, what happened? He filed another writ petition, my lord, father of the petitioner number 2, challenging the tender process, which your lordship has done.
challenging the tender process.
Tender process.
Why, on what ground?
On ground, my lord, his father
No
challenged.
conservation.
No, my lord. His father said, my lord, various grounds was taken, and this the honorable court said, my lord, page 64, lordship kindly have a look of the objection. This is another society run by father of the petitioner number 2,
But this Saikhowa Sadia,
my lord.
Hmm?
Yes. That belongs to father of the petition number 2. Having heard the counsel of the parties paying regard to the proceeding events, it is observed.
where are you reading?
Page
Okay,
64,
64, huh?
para 8, my lord.
Yes.
It is observed that the respondent authority shall proceed with the bidding process initiated by tender dated 27/23. It is further made clear the pendency of the writ petition shall not be passed for the respondent to proceed ahead with the bidding process. That is challenged by his father, the tender process. Yeah.
This petition is.
This petition number 2 is for. Then, my lord, what happened? Another writ petition was filed.
Anyway, we'll hear it some other time, no time.
Lordship next day, any week.
That case will be done. There is
Maybe it's granted, my lord, they will approach to the authority. I filed a review. Don't give settlement. They will clear that. No, my lord. Until and unless, my lord, I give a lot of years me elaborated.
There is nothing.
Suppose, my
You see,
lord,
one thing is that, is it your father had petition number 2, his father had also is in the fishery business?
yes, ma'am. I have an
Maybe he's
expert.
a teacher, man. He made him business, but what he has got to do with his son? His son is trained,
Fisherman,
my lord.
fisherman,
Yes,
he's a big fisherman.
My lord,
He's a big fisherman.
I don't know that. He's the secretary. He's the owner of the fishery. That's how it is.
That is the malevolent
Yes,
intention.
yes,
As in one,
My lord, his father may have several business. What it has got to do with the tourist guide?
I don't know, family business, ensuring that no one comes into their territory.
that society also.
Huh?
That
There are-
matter also all been done. Maybe.
There are
my-
Just a minute.
There are two petitioners, my lord.
And who is petition
The
number 1?
allegation has been made against petitioner number 2. What about petitioner number 1?
What about petition number 1?
One is the manager of the courthouse.
Who?
Run by them.
Number 1?
Yes, my lord. Petition number 1 is the courthouse manager, man.
Nothing has been said.
Huh?
Nothing has been said. On the
Where have you said it in your?
Yes, I'm
written
just saying
document?
that it is of the- No, no. Cover the symbol, the chop, the
There seems to be some, there seems to be some, I don't know, some big, issue with regard to this fishery.
My lord, why we want that the fishery to be stopped?
But your father is
In view
everywhere,
of the, my lord,
but your father is everywhere. Yeah,
What?
he's doing all types of business in and around that area.
Participated tender process also, my lord.
Huh?
He participated tender process also.
then his father is interested in the fishery. I'm not interested in the
But then
fishery.
you have not been,
What will come from
yeah,
the fishery?
you have not been able to show this court that the fishery is within the area of that.
Not, I am
that-
not within the area, my lord. It is 1 kilometer away from the Madhuri bill, my lord. What is the report, my lord? All along there, the forest department has been saying that because of the narrow stream of the fishery, my lord, it is not commercially viable.
You see, commercially viable or not is not an issue.
That is,
Now, how
that
can
is
you
the
stop,
main
how
issue, my lord.
can you stop them from doing business?
My lord,
How can you, what right do you have to, for them to stop doing their
because,
business?
my lord, because of the narrow stream, my lord,
Huh?
there may be infiltration to the Madhuri Matan field because they may come with a boat, commercial boat, my lord. He is in the fishery,
Or they might come to your, to that,
not mine.
to that,
They
to,
are
to,
the eco-sensitive zone.
that is a different issue.
That is why, my lord, forest department has overlain this. And in fact, my lord,
No, no, we'll hear it some other day. That
Let
is a,
it come on
that
Tuesday.
is a different issue.
let it come on Tuesday, my lord. Every day I am
Next week I'm having a division bench.
Any day your convenience, lord. After that.
my lord, at least, my lord, the review may be directed to be raised as my lord, at least.
Why urgency, my
Because
lord?
I have a right to review.
No, you don't have a right to review. It is only if this court finds that you are a necessary party and some right of yours has been
No, my
affected, then only.
That will be decided only in the
No,
review
so
petition.
no,
my
no,
lord.
no.
Admission of the review
No,
petition.
no, sorry, madam.
It is not the admission of the review petition. I pay for leave to file the review petition. That
And this
application is
court,
before
this
your
court,
lordship.
this court will not allow somebody just because you have asked for it.
No,
This
I am
court
not-
will have to be satisfied that some right of yours has been affected by the prima facie, it has been affected by the order. Unless you can show that, there's no question of allowing you. You're a third party in fact.
If the petition may be tagged, my lord, petition number 57.
No, there's no question of tagging right now. There's no question of tagging right. You'll have to show that your right has been affected. What right of yours has been affected? Nothing. You are scared that the fishery that is going to be given will somehow enable the successful tenderer to somehow slip into that.
I am not on the tender bench. I want that the fishery to be closed forever.
Why?
In view of them, that is, I also want for the report, various reports were submitted by the forest department, pursuant to the direction of this government. And even when the case of 550 was pending before the Supreme Court, the government called for a report for the forest department. In that report also the forest department.
What
has
is your
raised-
right?
My lord,
So what right of yours has been affected?
I am as an environmentalist and a forest
Yeah, as an environmentalist. Now, you have got to show whether the fishery that is going to be given to the other, to some person, to the successful tenderer, whether it is in some protected area, some forest area or something.
By under the government has also stated in the affidavit, my lord, filed in the 520 of 52. That affidavit is not placed before the order, before by the government.
With regards to the second state in paragraph 5, the district will answer it was to state that there were reports of some fisheries attacking here Tripura district calling with the CSPL. Chief Secretary Assam directed concerned this is to carry out joint survey to ascertain the method and take follow-up action based on findings of sub-survey by paper number CS number 7 constituted by the sitting India in its meeting held on 29/7/2017. The recommendation closure of the Kitu part of fishery as a major area of the fishery was found to be under DS. This is the part of the activity filed by the government. My lord.
After the, before setting the proposal to the central office, the fishery which come within the ambit of the Pitu national park, that has already been taken for consideration what part of the fisheries of those sales fisheries come with the ambit of the After 29/7/2017, edification was done, report was forwarded, showing that so far the present fishery is concerned with part of fishery, some part of the fishery falls within the ecosystem. That is why that part has been started from this fishery, and thereafter boundary has been redefined. After that, central government has notified on the basis of the report.
We made a small note. Right. This is the matter after a week.
Obviously.